मैडम साउंड क्लियर अच्छी तो मैडम
Beg to mention matters. Item 97 in the supplementary list matters. It is a covered matter. Lords should remember that income tax TDS, which has been deposited belatedly, and your lordships delivered the judgment in favor of the assessee because with interest the TDS has been deposited. So may I pray, lordship, I'll be much grateful if you take up this matter at 2 p.m.
Yes, yes. Keep it to 2 p.m. But the other side has to be,
I'll inform the others.
other side has to be.
Yes.
There's a
Much
covered
of-
judge- there's
It's a covered judgment.
I said that once you accept the
Yes, and that has been
penalty and
they
all.
went to the Supreme Court. SLP has been dismissed.
Okay, that's good news.
97.
Get that SLP number also, or the order. is
Yes,
there.
yes, I have got the order. ma'am.
Yes, sorry. Yes.
Item 109 yesterday list, my lord. The lord
Sir,
should direct
is
to
that
file the
matter?
note of submission. We have filed today, my lord.
Note of submission, take it.
Item 14.
Give it to
Sir, I'm also finding the.
Yes, give it. Put the-
Item 14, next one.
Pardon to mention a lot. Criminal revision number 463 of 2024. This petitioner has been convicted for 11 years, my lord, and he was out of service from job. That's why please kindly request to
24.
20.
When you come, you file it.
My lord, 2014.
14 matter.
14 matter.
When I was waiting for people to come, why have you not come? Today you know the list.
Item.
You can't come at your convenience and say that take up the matter. The time was there, you didn't come.
No, humble request to
Humble request is there, but I can't take up. Just see the how many matters are there. Regular hearing.
So whether it is coming under that case, my lord, where my lord, you also directly will take instruction regarding whether the petitions are alive or not.
Which one?
Case.
because
Permission
14
to?
conviction.
ତା ଭିତରେ ଆସିଥିବ ଯଦି ସେ ଯୋଉଟା ହେଇଛି ଗୋଟେ
Huh?
series of cases.
It's there, it's there. Then it will be
ସେ ଭିତରେ
listed.
ଥିବ,
Date is fixed.
ମାନେ
You fix that is all.
Obliged.
Which,
ଯଦି instruction ଥିବ ଏଥିରେ ଏଥିରେ
ହଁ।
ପକାଇଥିବ ତାହେଲେ ଆସିବ।
yes, along with this.
My lord, item 14.
And
next
same
one.
order. What is the age of this gentleman?
My lord,
କେତେ ଯାଉ ଆସିବ ଫାଇଲ କଲା ବେଳେ?
at that time 56 around. Now he's retired.
Retired. Yes,
Item 14, next to it, my lord.
adjourned.
My lord, item number 75, permitted to withdraw, my lord.
75 withdraw.
Number 77, not present.
Not press 75.
Pardon to mention, my lord, today's item number 76, kindly taken up next week.
70?
Six.
Bail matter.
No, my lord, CRLMs.
Stay is there.
No, stay in AD is gone, but not
Stay is
back.
there or not?
ଠିକ ଅଛି ନାହିଁ
Entry order, entry order. You
Instruction
be sure about it. Yes, next.
obliged.
Be sure then. Yes.
Item number 7.
70.
7.
7, yes.
May I pray for adjournment?
Adjournment. Okay, adjournment.
ମାନେ
Bail.
No, my lord. CLS. Press.
Entry order.
No, no, no. No entry mode.
ମାନେ item 67, my lord,
Hmm.
state filed this case, my lord, but neither AD nor the unserved notice return, my lord. Cancellation,
Press notice.
ନା ନା ଯାଇଛି return ହେଇନି।
Acha, awaiting notice.
Next.
Awaiting.
67.
67. Yeah. 67 awaiting. Any mentioning? No mentioning. Any mentioning? Yes. Yes. And in this matter, I have already granted bail, but the problem is I subsequently found that the name of the victim is found mentioned in the order. It has to be deleted. So that is the reason I got it listed. I realized that the child victim. And
My lord.
you are appearing, Mr. Sahu?
Yes, my lord. Yes, my lord.
See in the
Third-
second paragraph, name of the child victim is unfortunately mentioned. I think that That's all.
Typographical error, Your Lordship.
Typographical error. They committed, I know. The
Your
name of
Lordship,
the-
may I pray one thing, my Lord? Your Lordship, may kindly direct the registry. They will upload the order and I will use that
Yes,
order
now,
to
immediately,
the court below.
immediately within 10 minutes it will be done. Right on. Inadvertently, inadvertently in the order dated 8/8/2024, the name of the victim mentioned in the para 3 of the said order. The name of the victim for the forthwith, this is said order. Corrected order to be uploaded immediately.
My Lord, the learned court below will use the uploaded order, Your Lordship, may kindly. Because you already obtained the certificate copy.
Communicate this order to the learned court below.
Grateful.
Item 1.
Here.
In this case, my lords, the appellant Sam, my
Yes,
lords, died, my lords.
Died.
But
matter
the
was-
SP Barampur could not
When-
furnish the date of.
Okay, right on. When was it heard? When was it heard? No, when it was heard.
My lords,
Okay. On 9/8/2024, this appeal was heard and judgment was reserved. But it was informed subsequently that the SP Barampur vigilance have intimated this court subsequently that the sole appellant has died. Therefore, the appeal stands awaited.
permits, my lord, the same line of instruction received in 105, my lords. 105 of lordship. Cost list.
105. Barampur.
It's a case for 1 minute, sir.
SP.
SP is SP Sambalpur, SBP, Sambalpur.
SB Sambalpur report.
That died on 2/12/2011.
2/12.
2nd December 2011.
Okay.
SP Sambalpur.
SB Sambalpur report.
This pertains to 105 of the serial number.
105, huh?
The next,
105 abated.
next case is 106. 106. The appellant died. No date could not furnish, but SP Sambalpur has informed.
SP Sambalpur vigilance have informed that the sole appellant in the present case.
This
is
pertains to 106 serial number.
so abated. Yes.
The third one is 107. Here also the appellant died on 25th April 2019, 25/4/2019. SP Bhubaneswar has reported this one.
Okay. Abated. See, these matters are unnecessary pending for years.
Because of Lordship NDR Muller, it's gathered momentum.
Otherwise, this would have been there in the,
But Lordship is exploring new avenues to
I know.
find out some mechanism to that this matter should not gather further dust.
Or at least these things will be, if anybody is interested, they will move applications.
My lords, may I submit item 91 also?
91 also same.
No. 91, my lord, there are two matters stacked, my lords.
Yes.
The 91, the first one is 151/2006. My lord, the flag X contains the whereabouts. That flag X.
151.
No. Serial number 91.
91, 151. That
141 of 2006,
Yes.
Jivera. That's the noting appended to that particular case. That's flag X. That contains the whereabouts.
Flag X.
There is a note appended, the registry appended that at
Yes.
91
Submission of
notes.
report regarding the current status.
Yes.
Wedding has been passed away. Passed away since 25/4/2091.
That is inside that flag X, flag X.
Yes.
Then Lordship may
Yes. 91 criminal appeal number 151 na? Criminal 151.
Jivera.
The sole appellant in the present case has reported to have expired on 25/4/2016. A report has been report dated 15/7/2024 by the SP Vigilance Sambalpur has been placed on record.
And my lord, the second case appended to this particular case, that is appeal number 192/2006, my lord. my lord, somebody has appeared, my lords. That's my lord, is about, that should be tagged in that.
Second matter, let it be the things.
That's all. my lords.
Four matters at least, four matters. Yes.
Item 2.
But in fact, in the last month only, my lords, the manner in which number of cases were disposed of, my lord. This month, my lords, my calculations that disposal has come down drastically, my lords.
Because of
That's why, because
bail
this
matter.
instruction,
bail matters and all.
correct. my lords.
Yes.
Item 2.
Yes,
I'm
sir.
applying for the petitioner's your lordship.
Yes.
The present application has been filed for questioning of the proceeding initiated at city case number 3041 of 2019, pending before SDGM Bhubaneswar lordship. The allegations in the FIR is that the petitioner along with another person have
That's
acted.
the cognizance order.
Yes, Your lordship.
Yes.
Charge sheet has not been filed. for us.
Just it filed.
Cognizance order.
The cogni-
They charge sheet have been
on basis of I'm saying not on basis. On basis of the charge sheet, the cognizance has been taken.
Whether
Where
they
is
have
the
filed
charge
charge sheet. Charge sheet.
We have not filed. We have. Lordship, the whole contention is that these people are petitioners are the neighbors of the complainant. The allegation says mostly that because of the previous enmity between them, like the opposite party has a pharma company, which has
You argue all this thing at the stage of framing of charges. Right.
liberty.
And counsel for the petitioners, in this petition is challenging the order dated 9/9/2020 passed by SDGM Bhubaneswar in city case number 3041 up to 2019. 29. Next. Then counsel for the petitioner, after arguing for some time, seeks to withdraw the petition to raise all the points before the court below at the appropriate stage. With this liberty, the petitioner is disposed of. Yes.
Published.
Your lordship, 6 for adjournment, your lordship.
Your lordship, I am appearing for the victim, my lord. Here, this is a case of compromise. Your lordship may kindly come to the page number 23 and 24.
Item 3.
He says, have you settled the dispute?
Yes, your lordship. Your lordship, page number 23 and 24 may kindly see.
24/20.
23, 24.
Yes.
The affidavit filed by the victim, my lord.
Okay. And then bring them
Tomorrow, your lordship.
tomorrow.
No, I would not produce them tomorrow, your lordship.
Settle the dispute. This is
Yes, your lordship, settle, but I ସକାଳେ contact କରିଥିଲି ହେଲାନି ତ
Monday.
My lord, the victim
Parties conjointly submit that the parties have settled their dispute.
and
Monday ଛୁଟି ଅଛି.
Adjournment. Tuesday,
Yes.
lease the matter on 20th. Yes.
Item 4.
We have compromised the issue, your lordship. We have paid the amount for 20 case.
Yes.
1 lakh was paid, and affidavit is to be filed.
Who is appearing? You are.
He is the counsel, my lord. This is.
Yes. Is it 420? They have settled the dispute.
We have settled the dispute. I think to check the new.
Give the check. What?
Yeah, Sangir Achi.
ଅଛି ତ? There is original there. Photocopy there. Original there, the photocopy चाहिए.
There is a needs little correction in the main petition. Barhampur has been written in the cost title. It should be Chhatrapur.
Okay. Who is
The complainant.
Munafi Saraf? You are Munafi Saraf. And Surendra Behra? Munafi Saraf, Surendra Behra, you got मिलेगा पैसा?
Munafi got.
Munafi, obviously Munafi will get. Munafi got it. This is 3 lakh.
1 lakh was paid earlier. That is mentioned.
Right now.
4 lakhs.
At the instance of opposite party number 2, FIR number 2 also came to be registered against the petitioner. The allegation against the petitioner is shown. The petitioner and opposite party number 2 are present in the court. They are being represented by the respective counsel, and they filed their self-petition copies of the Aadhaar card to establish their identity. The counsel appearing for the parties conjointly states that the parties have settled their dispute. An affidavit, a joint affidavit has been
Affidavit.
joint affidavit dated.
Nice, sir. Affidavit only. Informant.
Affidavit by the informant.
Informant.
An affidavit on behalf affidavit dated 13/8/2024 has been filed on behalf of opposite party number 2, intrally stating that he has settled the dispute and received the settled amount of 4 lakh rupees. 1 lakh rupees he had already received earlier by case on 19/6/2024, and in the court today a draft of rupees, demand draft of rupees 3 lakhs has been paid. He has accepted the of settlement to his satisfaction. Therefore, he doesn't want to proceed against the petitioner. Take the affidavit filed by the opposite party number 2 is taken on record, and regard being had to the fact that the parties have settled the dispute and the disputed amount has already been paid. Nothing survives in the matter. Therefore, the FIR number 2 so and consequently proceeding arising therefrom are passed. Yes.
Should be Barhampur.
बरहमपुर लिखा है
सॉरी छत्रपुर
छत्रपुर हाँ एफिडेविट देखा
सर प्रेयर रे हमर भूल रे बरहमपुर लिखि दिथिलु छत्रपुर
FIR number 17 yes
containing the xerox copy of the draft your lordship
and the affidavit and the photocopy of the draft is taken out of
Mr. LK Sahu appears for the informative.
LK Sahu opposite party number 2 LK Sahu yes. Next.
Your lordship, I have got a small submission.
Yes.
I've been disturbing you, my lord. In item that my learned friend, he submitted the notes of submission. Yesterday, matter I was arguing.
Yes.
One thing your lordship may keep in mind, my lord, that the proposed witness stays in Canada.
I'll take. Yes. Yes.
For submitting this, my lord, this case, if my lord, I would lordship. Kind attention. Some error is there in the order.
Which order?
Data case in the filler. Connecting case. What case order, out case,
That I know. We have a very competent staff. That's the problem.
Actually, here he has filed the cognizance. Cognizance dated 15/2/23. 15/2/23 cognizance he has challenged. But in the order,
what is the mistake in this order?
Mistake hochi data case thala gotte case adi thela 2493 so hota 2988 he is sede adi case ta 21 thala achi bole nu online order ta rakhi
This order should have been in this matter.
yes that order should have been there
Release both the matters. I'll see. Release both the matters.
20 and 21
Item 6.
After lunch, but another matter is lordship fixed that income tax matters. Can you take out tomorrow, my lords? Tomorrow after lunch, please. I've got instructions. It'll take some time. But day after tomorrow, whatever comment.
Next week,
My lord, as per direction of this report, I am filing the affidavit.
you please file it in the registry because all
RC1 Kali
Kali Kali maybe problem. Because after lunch, I may not
Income
take
tax
much
matters.
matters because
Let's fix a date and
Tuesday, Wednesday,
entry model may be extended.
entry model to continue.
And
We'll
your
see the
lordship-
date and give
Your
entry model.
lordship may reflect, I have served a copy on my.
The
learned brother.
copy,
Additional
Mr.
affidavit.
Biswal, learned counsel for the petitioner, seek to file the additional documents pursuant to direction dated 5/8/24 and supplies the copy,
Sorry.
advance copy to learned counsel for the state, Mr. Das. Let him do so. Reach the matter. Next week, next week.
Coming week, yes.
And entry model to continue. Yes.
Kebe asu at.
He will give a date. देखिए
I'll get it.
30 तारीख।
30 तारीख.
Ten. Yes. Yes. 10. Nobody there. What is this matter? Vigilance.
I have got another matter with vigilance, 110, 102.
102, yes. 102, who is appearing?
If they will do it, I will wait, otherwise you will.
I don't think they can do it. I don't. Same date, 30th. Let him, you make him free unnecessary violence.
That is their revision, of course.
Okay, no problem.
102.
100. Then item 10 is the vigilance case. Pass over.
Item 11.
My lord, today I am appearing for the petitioner.
You want time?
No, my lord, I will argue the case. Your lordship, as your lordship it.
Tell me what, this is a bail application, what is this?
Yes, my lord, this is for offenses alleged under section 376, clause 3.
Huh?
And read with 6 of the POCSO Act, my lord.
My lord, I am appearing for the informant for legal aid, my lord.
Informant.
My lord.
Ready?
Yes, my lord.
Are you ready?
Yes, my lord.
What are the allegation?
The allegation is that, my lord, I have to convey the victim to the laws and thereat I committed rape on him. So for the evidence,
164.
my lord.
Read the 164 statement. Do you have in 164? CD is there?
Yes, yes, there.
164.
Yes, no. 164 specifically mentioned the present petitioner kept physical relationship and age of the victim is 13 years, my lord, only, my lord. His reading is class 7, my lord.
My lord, the evidence.
You are in custody?
Yes, my lord, since last 18 months.
Date, you take, give me the date.
24 March 2023, my lord. 28th March.
Boy is 22-year-old. The victim has examined?
Yes, my lord.
In the court?
Yes, my lord.
Oh, please read on record. Let Constable, the petitioner submits that the victim has already been examined in the present case. He wants to place on record the evidence of the victim recorded in the trial court. Lease the matter after 1 week. Appear so entered appearance on behalf of the victim. Victim and files Vokalatnama, same is taken on record. And give advance copy to him. Yes, please. Yes, next.
Item 12, item 10,
Item 10.
You will ask pass over, and whenever you come, I'll have to take it.
Sorry, ma'am.
Pass over is at 2 o'clock.
Obviously. Sorry, my lord. I say one Passover, that is why I am mentioning.
No,
Otherwise, I
don't mention in between.
Sorry.
Maintain the decorum of the.
my lord, oblige.
Yes. Next.
May I please, yours?
Yes.
My lord, the case is under section 294, 323, 363, 366, 376, clause
Yes,
3.
yes. Forget about that.
My lord.
Yes,
And
tell
the
me what are the allegations?
petitioner is
376.
my lord, 376 arising out of law affairs between the
Assuming you are in custody since
my lord, 5th 11 2022, my lord.
22.
My lord.
What are the allegations?
My lord,
You
page
have yes, sir. You have the.
Yes, 164 I have, my lord.
Read it.
My lord. ଦେଉଛି ଗତ 4 ଅକ୍ଟୋବରରେ ମୁଁ ତାଙ୍କ ଜମି ପାଖରେ ଦେଖା ହୋଇଥିଲା ମୁଁ ସେ ମୋତେ ଭଲ ପାଇ ବୋଲି କହିଲେ ମୁଁ ସେଠାକୁ ଗଲି କିନ୍ତୁ ସାଙ୍ଗରେ ସେଠାରେ ସେ ମୋର ଇଚ୍ଛା ବିରୋଧରେ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲେ ତାପରେ ସେ ମୋତେ କହିଲେ ମୋତେ ବିବାହ ହେବେ ସେ ଦିନ ହିଁ ମୋତେ ସେ ତାର ବଡ଼ ମା ଯମୁନା ପାଙ୍ଗି ଘରକୁ ନେଇ ରଖିଲା ମୋର ବାପା ଏହି ବିଷୟରେ ଜାଣିଲା ପରେ ଗାଁରେ ଭଦ୍ରଲୋକଙ୍କୁ ଡାକିକି ମିଟିଂ ବସେଇଲେ ସେଇ ମିଟିଂରେ ପାଙ୍ଗି ମୋତେ ବିବାହ ହେବ ବୋଲି ରାଜି ହେଲା ଓ ତାପରେ ବଡ଼ମା ଘରେ ମୋତେ ରଖିଲା କିନ୍ତୁ ଏହା ପରେ ସେମାନେ ମୋତେ ଅତ୍ୟାଚାର ମାରପିଟ କରି ଘରୁ ବାହାର କରିଦେଲେ.
And what is the age of this girl?
The date of birth 8/7/2006.
What is the age?
Age ହେଲେ 23 ହେଲେ 16 ବର୍ଷ ହବ.
17 in FIR, my lord, she is
22-year-old.
my lord.
22-year-old. And he's in custody since
2020.
5/11/22.
My lord.
FIR is 11/4/23 ତା ପୂର୍ବରୁ କେମିତି ହେଲେ ମ?
You are in custody before the FIR.
Sorry, my lord.
Least after 2 weeks.
11/5
Least after 2 weeks. Next.
11/5 2023.
Next week. Let's read 14.
মানে 11/5/2023
Huh? 13, yes, 13 next.
13.
Adjourn. Yes.
Mr. Could you kindly take out this matter next week?
Adjourn, yes.
Item 15.
Yes, 15,
item 15 item 15
15, yes.
But here the petitioner before my lord is in custody
ये
since
13 जुड़े कोई ना कस्टडी बोला कोई थे 5/11/2022 कोई ना लीव आफ्टर 3 weeks misleading sir. Here.
My lord, here the petitioner before my lord is in custody since 25/2023
25
33
25
हाँ 20/5 May
25 okay 23
23
yes
for being charge sheeted for the offence under section 302/34 of IPC, my lord. But in fact, the case of the prosecution is that the FIR named accused, namely Salman Ahmad, he committed murder of his second wife and 2 children.
what is your role?
I was nowhere in the picture, your lordship. I was neither named in the affair nor there are any eyewitness those who have implicated me. But during course of investigation, IO, basing upon extrajudicial confession of the principal accused, namely Salman Ahmad, before one witness,
Yes,
namely Ajit Kumar Naik.
Yes, Mr. Extrajudicial confession.
My lord, that apart, my lord, another one.
Yes.
That apart, my lord, in the meantime, the 164 statement of that witness to who was witness to extrajudicial confession, his 164 statement has been recorded, and he has not uttered a single word in respect of.
Okay.
I'm sorry.
Except that what you.
But that is, my lord, extrajudicial confession before the, my lord, the Ajit, my lord. He has confessed that he, along with this petitioner, my lord, committed a murder of the.
But you have recorded the
Okay.
statement of that Ajit.
On the last occasion also, I had sought to my knowledge.
Let's see. In 164 he doesn't say anything.
ପଢି ଦଉଛି, if your lordship permits me, I will read the statement. ମୋର ନାଁ ଅଜିତ ନାୟକ, ପିତା ଟୁନା ନାୟକ। ମୁଁ ମୋ ବୟାନରେ ଏହା କହିବାକୁ ଚାହୁଁଛି କି
Read relevant part. You can't read the entire address.
my lord, in fact, it's a 8 to 10 line paragraph, but
Read it.
Okay. ଗତ ତା 9/5/2023 ରେ ମୁଁ ଘରେ ଶୋଇଥିଲି। ପ୍ରାୟ ସମୟ 3:30 ରେ 2 ଜଣ ସଲମାନ ଓ ବାବୁ ଖାଁ ମତେ ଯାଇ ଡାକିଲେ, କହିଲେ ଆସେ ଚାହା ପିଇବା ପାଇଁ ଯିବା। ଚାହା ପିଇ ସାରି ବୁଲାବୁଲି କରି ସାରିବା ପରେ ସଲମାନ କହିଲା ଯେ ମୋର ଆଜି ଟିକେ ଘରେ ମୋର ଦ୍ୱିତୀୟ ସ୍ତ୍ରୀ ସହ ପାଟିତୁଣ୍ଡ ହୋଇଯାଇଛି। ରାଗରେ ମୁଁ ଦ୍ୱିତୀୟ ସ୍ତ୍ରୀ ଆଉ ମୋର ଛୁଆ 2 ପୁଅ ଓ ଝିଅ 2 ଜଣଙ୍କୁ ମାରି ଦେଇଛି। ଆଜ୍ଞା
ମୁଁ ଏ କଥା ଶୁଣି ଡରିଗଲି।
ଆଜ୍ଞା ସେ ଡରିଗଲି। ମତେ କହିଥିଲା କାହାରିକୁ କିଛି ନ କହିବା ପାଇଁ, କାହାରିକୁ କିଛି କହିଲେ ମୁଁ ସେ ମତେ ମାରିଦେବ ବୋଲି ଧମକ ଦେଇଥିଲା। ସେଥିପାଇଁ ମୁଁ କାହାରିକି କିଛି କହିନଥିଲି। ପେପରରେ ନ୍ୟୁଜ ବାହାରିବା ପରେ ଫୋନ କଲରୁ ପୋଲିସ ମତେ ସନ୍ଧାନ ପାଇଁ ମତେ ପଚରା ଉଚରା କରିବାରୁ ମୁଁ ସତ କଥା କହିଲି। ସଲମାନ ଓ ବାବୁ ଖାନ 2 ଜଣ କିଛି ଦିନ ତଳେ ସାଙ୍ଗ ଥିଲେ। ତାଙ୍କ ସହିତ
You are Babu Khan.
I am Babu Khan, your lord.
Babu Khan, you are Babu Khan.
Triple murder case, my lord.
I am Babu Khan.
The principal accused, my lord, absconded, my lord. His whereabouts not known, my lord. This petition arrested. The moment he will release, my lord, and 2 children, my lord, they have been brutally assaulted. This petition also present with that. Extrajudicial confession.
Wait.
Also,
I'm petitioner is accused in so. The principal accused in the present case is absconding. There is enough material placed on record to create suspicion about the involvement of the present petitioner. And there is extrajudicial confession before one
Ajit Naik.
Before one Ajit Naik. Although the statement of the witness Ajit Naik has been recorded under 154 CRPC, however, till the material witnesses are examined by the prosecution, in the instant cases, the petitioners cannot be pleased on bail, particularly for the reason that this case involving murder of triple murder, and principal accused who is an alleged accomplice of the present petitioner is absconding. I'm not inclined to entertain this petition. However, liberty granted to the petitioner to renew his bail plea after the material witnesses in the present.
Specifically, your lordship may indicate after examination of this Ajit Naik, your lordship.
I have written that. Yes.
No.
Next.
Because
373, my lord.
notice, my lord, notice were not at filed, my lord.
Yes.
But in this case, my lord,
Hmm.
373,
Notice, my lord, earlier issue notice, my lord, but in fact, they have not filed the requisites, my lord. Requisite for issuance of notice approved to by.
Notice was issued to oppose.
Another thing, prisoner fact X, my lord. Prisoner, my lord.
from the jail custody, he has given the.
If he in jail custody, who will file the requisite?
No, my lord. Not looking at, my lord. Prisoner person there, my lord.
If that is allowed, man, somebody will appear, man.
So who will file the requisite then?
For that is the
Send the prisoner person, that is, if he allowed, man, this council will appear, he will file the requisite. That is the matter. Prisoner petition.
Allow the application, the prisoner's petition is allowed. And due to non furnishing of the requisites, the notice to victim has not been assured, leaves the matter after 3 weeks. Necessary steps may be taken for the purpose of serving the victim in the case. Yes.
19.
19.
Item 18.
18? Yes.
18. No, 18. Withdrawal file.
No, because he has filed the withdrawal now because there was an interim bail. He could not surrender, so that reason he has been surrendered. No, my lord, the petitioner is in custody.
You are for whom?
A petitioner. He is languishing in custody since, my lord, 7/8/2023.
You have withdrawn the petition. What can I do?
No. Earlier conducting advocate, he is no more with us. Already died. He has filed the withdrawal petition wrongly. Wrongly has filed the withdrawal petition.
How do I know? He has filed
Mr.
withdrawal petition. I accepted it. And now.
Mr. D.R. Mishra, he was also no more with us. He has filed the withdrawal petition. My name is there. Only, my lord, they decide the matter on merit. 7/8/2023, he is in custody. More than near about a year, he is in custody. Both of them also.
File a fresh one.
Fresh one, withdrawal file.
File a withdrawal. File a fresh one. A memo has been filed. I can't ignore. You file a fresh one. No problem. There is no res judicata in bail.
Criminal matter, no.
Then why do you worry?
My lord, only sir, noting is there because interim bail was granted. He not surrendered in time.
But he has surrendered. That's what.
Yeah, now he has surrendered. That is for that reason he has also filed a withdrawal memo. Perhaps he is not abide by the.
Maybe, but what to do?
My lord, as per my lordship's honor.
You file a fresh.
Yes.
My lord, item number 17.
19.
I have read down. Item number 17.
19.
17. 17, ma'am. My lord.
There is a withdrawal memo. Yes.
I have prayed for to withdraw.
Yes.
19.
Report call for that is fact E, my lord.
Permitted to withdraw, that's it.
Oh, permitted to withdraw. Yes. Withdraw. Yes.
20.
Please, your lord. Lords, I am there virtually.
Yes.
Here I am in custody since 14th of April 2023, my lords. In connection with a case under 20B2C of the NDPS Act.
Recovery?
My lords, I am alleged to be passenger of a car from which 150 kgs and 995 grams of ganja was recovered.
How do you say that you are a passenger? You say no
That is
conscious.
the prosecution story, my lords.
Yes.
Driver may not accept, my lord.
Prosecution story is that the driver fled out.
My lord. This man got a red-handed, my lord, and my lord, total ganja, my lord,
150.
150 kg, 995 grams, my lord, recovered, my lord.
This is a car.
Car, my lord.
Yes, Lord. It's a private car.
When the police raised them, the car dashed with the pillar. For that reason, the driver jumped from the car and went away.
And this
And,
man was.
the driver also belongs to Bihar, my lord. The owner of the car also belongs to Bihar. Their whereabouts not known. They have not been arrested till yet. And so far this petition, he is also belongs to Bihar. And charge sheet submitted against him. And the chemical evidence report, my lord, that has come, my lord. My lord, it is found that it is ganja, my lord.
Have you placed it?
My lord.
Placed it.
My lord, today I received.
When the chemical analysis report came?
Later on, my lord.
When?
They left it.
Charge sheet filed on?
Later on,
In the charge sheet, column 15 doesn't show it.
Subsequent, my lord. Subsequent, my lord.
Where the charge sheet was filed here?
Charge sheet, my lord, filed on 10. Charge sheet, my lord, on 10/10/2023. Already, my lord, sent for camera. That report has not come. Later on,
Now, have you placed it on record? Now there is a change. Your bail application was rejected on 9/11/2023. Now, in a changing circumstances, you file a fresh one in trial court.
Charge has already been framed.
The petitioner is agreed by the order dated 9/11/2023, whereby the application for bail has been rejected. Subsequent thereto, the prosecution has filed the chemical examination report on 12/11/2024. Charge sheet has been framed in the instance.
On which date, my lord's chemical examination report is said to have
On
been?
the changing circumstances, petitioner may renew his bail application before the court of first instance. With this liberty, the petition is disposed of. Yes, next.
May I pray that the order may be uploaded, my lords?
Yes, today only. Today only.
21.
21.
I am appearing. My learned friend is also showing that he has the power.
You decide who.
No, no, I have nothing to say, but he has not taken my consent. It is a trial court brief.
Next week. Yes.
He has appeared later on. We should have asked.
Next week.
Prisoner petition is there, madam.
22.
21.
21 next week. You decide. Yes.
22, my lord, as per last order, my lord, the victim may appear through the virtually before the IS.
Allegations are under 420, my lord. My lords, he is the interface payment operator of an informant company. What happens? It's like UPI, my lords. The money comes to my account as the agent of the principal company. Then T+1 date, my lords, I transfer this amount to the principal company. T is the date of transaction.
Last time I said that the manner of the transaction, I wanted to know. You have got it?
I have prepared it. Draft, my lordship.
Have you given it? Given it to me?
Only a diagram for your lordship. I'm giving it. My lord, what happened, my lord? That was, the fraud was committed in means of, my lord, that is QR code. There is two types of QR code. One is P2P, another is P2M. P2 means person to person. Suppose I transfer some money to my friend in QR code, that is P2P. P2M means transfer of money from person to merchant, to the business persons, my lord, to the
through a wallet.
To the wallet, my lord.
Okay.
And in the P2M, there is also two types of wallet, my lord. P2M means suppose we scan the QR code and the amount. And another one is dynamic. In dynamic, you
once you scan the
automatically that amount. This is fraud is relating to that dynamic QR code. Okay. Automatically it will come by. My lord, kindly see the graph I have prepared.
Yes.
The total amount, my lord, within 7/6/2023 to 19/6/2023. The total, my lord, there was before that there was an agreement, my lord, that the informant company and accused company had agreement. From 1 to 10 rupees, there is 3% plus GST, and 100 to 25, there is some.
Okay.
Then, my lord, what happened in 7/6/2023 to 19/6/2023? My lord, total fraud was committed 15 crores 9,21,100.
You said 7 to 7?
7/6/2023.
23 to?
To 19/6/2023.
23, okay. 15 crores.
15 crores, 9 lakh
Whatever, about
21,000.
15 crores, yes.
Right.
Hmm.
And in the meantime, my lord, what happened? That my lord, in the graph, you will see from the informants.
This is in violation of the contract terms.
No, my lord, that is what happened, my lord. The money, it will go to the informants company. Then the settlement will be made. So in 15 crores amount, the company only get, my lord, 75 lakhs 95,000.
Accused company as a commission.
Informants company.
Informant commission. Okay.
Then, my lord, settlement will be made and he will give there is percentage.
Hmm.
When they say 70 lakhs he got, then he inquired the matter that the QR code, which was dynamic QR code of 20,000, that was came as 1 rupees.
Okay.
20,000 was manipulated. Was 1 rupees.
Okay.
So that 1 rupee scan was given by the petitioner's company, who is near their relatives. They have scanned and 1 rupees was credited to informants company. Instead of 15 crores, informants company got 75 lakhs. So when the company inquired the matter, my lord, so there was in the wallet 2 crores 83 lakhs 91,000 was pending in the wallet.
Okay.
That wallet, my lord, the informants company, that amount has ceased. That from the wallet, informants, they have not raised voice. Why my account was, you have freezed such amount? They have not. So, my lord, the 15 crores, 75,000 he has got, that informant company got. Total is 14 crores.
And what is the then the fraudulent amount then?
My lord, the 75 lakhs.
75 lakhs.
75 lakhs the company got. So total amount is 14 crores 33 lakhs somehow. And my lord, the company has seized the sum.
The entire amount is not the fraudulent sum. It is part of it.
15 crores was fraudulent. Subsequently, company got 7 lakhs. And 14 crores 33 lakh is there. And company seized the amount which was in the wallet. That is 2 crores 83 lakhs.
Yes.
So subsequently, my lord, 11 crores 49 lakh and some odd is there. So your lordship may see that it graph, my lord. When the dynamic QR code was come from the informants company, it goes to the petitioner company and it comes to the public use. That, my lord, public use. I have marked that.
Public, yes.
In the middle portion, my lord, that accused company has manipulated.
Then it goes to the petition company. Thereafter, it comes to
informants company get 75 lakhs 95,000. And your lordship may kindly see. So they have, my lord, what I have stated that they have not raised voice. Why you have seized 2 crores rupees? 2 crores 80 lakhs in my wallet. And my lord, kindly see the order dated.
So then the accused company is the interface company among them.
Accused
You are the
company-
interface.
And this dynamic QR code, who has generated? He's saying, I have generated. I cannot generate it.
No.
He has to generate it.
Yes.
And it is his generation. How does he blame me? I don't understand.
Yes, informants company informants company generated.
Then if it is a dynamic one, if the informant company generates it,
yes,
the amount automatically comes there.
My lord, yeah,
then how can you? That's what he says. How can you blame him?
In between that, my lord, when from the generation to the public, my lord, at that time, my lord, its company has manipulated 20 lakhs.
Is there any scope of settlement?
My lord, kindly see.
We have not taken so.
My lord,
my lords, what has
can you
happened?
see the order
Just
dated
explain, my lord.
Let us do one thing. Let us do one thing. I'll put it next week. You implead the informant company.
Well,
Implead the informant company. Let us see if it can be worked out, because this is very highly technical thing. You know,
that is technical.
You don't know where the crime really is committed.
I'll get a
Neither you know nor none of us knows. The way these people do it is very difficult to understand.
Actually, my friend, a top cyber expert, he said it is not possible on our part. For example, UPI money goes to, let us say, X bank. Now the merchant doesn't get it. Merchant will start inquiring. For example, I am having a coffee, let us say at Coffee Day, my lords. I put this QR code and it has to go. It goes to the wallet. Then it goes T+1 day. It goes to that particular company. Now, this is already in their computer. once the transaction is made, it goes directly to the computer. The money might not have come. So if that amount is not received, immediately the company computer shows that this is the error. Why money has not come, they will start inquiring. Will they wait till 12 crores or not, my lords? And that most probably what has happened, my lords, their employees might have taken away the money, squandered it, because only for this 2 crores which he says, because the transactions are going on. So whatever was in my wallet, he has taken, and this question of protesting against it, he was in custody, so he could not have protested. Now the other things, my lords,
and moreover, I tell you, these are the whatever has been done. These are all documented.
I am admitting that.
Documented. Why should you keep him in?
My lord, that I can. My lord, kindly say the order dated 6/4. My lord, 6/4/24 order. Your lord.
6/4. 6/4/24.
My lord.
Yes.
My lord, kindly see that order. My lord, para 2.
Further, if granted the same time, sometime, and you deposit the balance amount of. Acha, you have said that.
My lord, that is my calculation is, my lord, 11 crores 43. He has admitted to give. So, my lord, if my prayer is, my lord, if he will be in the custody, then company will not get benefited, will not be benefited. So he has admitted that there is if he will release on bail, then he will deposit such amount. Your lordship may.
You made some statement. That's
you.
My lord, what had happened? Someone had appeared online. And I don't know what prompted him. He said, I'll pay back.
You say that you will pay back.
And thereafter, all
let us call the complaint company. We'll persuade him and pay something and try to find out.
He cannot, because he has not taken the money.
I know that.
Your lordship. And what he is also saying is contrary to the charge sheet. But anyway, your lordship.
This drawing.
This drawing is contrary to the charge sheet.
Very difficult to.
My lord,
Mr. Milan Karangol and counsel for appearing for the petitioner submits that on query from the court submits that he would be instructing his briefing counsel to take steps to implead the complainant company. He may do so within 2 working days. Least the matter next week, Friday.
Well,
you implead immediately. Let them come, we'll find out.
The client is saying, if I'll come out, I'll help them to get their money.
That's right. The idea is but you have somehow made the statement that you will pay 11 crores.
Well,
But how will you get out of it? There is a proceeding.
In the next order,
Yes.
Next order, we have specifically averred that this was without my lord consultation.
But for the bail purpose, all these things, these transactions, the online transaction which is already recorded.
All my lord,
So,
that you documented evidence.
Keeping him in custody is,
Purpose will be solved.
let him come. Let him come. Let us see.
My prayer, may I pray, my lord, that it's some deposit without any prejudice.
Let the complaint company come. Then in his presence, we'll do it. Okay. Yes.
Oblige. 26.
My lord, I may pardon my lord. I may be pardon to mention, my lord. In a last occasion, your lordship has directed to obtain the instruction regarding the authentication of the affidavit has been filed by the informant. My lord, it has not received, my lord. So your lordship may kindly give a last chance for me.
1 week, huh? 1 week. Yes.
My lord, item 25, my lord, I'll include him as party, my lord. Notice to go through the
notice
state, my lord.
Notice to go. No, yes, you, sir. Big company, they can come.
That's the notice I'll serve.
Doesn't happen, then you tell me. Yes. Yes.
27.
The question to order of this on the statement of the victim has been recorded. I've applied the certified copy. I'll get 2 days time to.
Then you go to that court.
No, pursuant to order of this honorable court, but the statement of the victim has been recorded.
Okay.
And that is.
2 weeks. Yes.
28.
28, I am filed for the interim application on ground of mother's application.
Mother is not well.
No, she is suffering from cancer.
To me.
For which.
Informant, my lord. Last occasion, my lord was directed to local IAC.
Yes.
Make an inquiry.
Have you got any information?
No. I am praying before
Get
your
it, but the mother is suffering from.
my lord,
cancer.
my learned friend, previous learned friend has sent the letter, my lord. And yesterday, from yesterday nights, I was, my lord, contacted.
If something wrong happens, then you,
One day more,
everybody will regret.
Your lordship may kindly allow to me 1 day more. And I will comply.
20th, huh?
Yes.
20th. Wait till
Okay.
20th. Huh?
29.
Shall I allow interim appellate subject to
Yes, my lord,
verification?
Yes. My lord, it's a
Serious offense.
I know, that's the reason he knows.
For a moment. First, they have kidnapped the victim,
And,
made it assault him, thereafter make the videography and it virals the assault to the videography. My lord.
Yes, my lord.
Thereafter, my lord, the
All these things are all right, but what the mother will do?
mother is now, she is in home, my lord. She is staying-
Suffering from
I have
cancer.
I
have filed all the documents. Okay, put it next week. Yes. There is objection. Yes.
29.
My pleas, your lordship. The petitioner is in custody since 1/9/2023, my lord.
1/9/2023.
For the offense 376 N and 506.
Yes.
But the victim is a married lady, my lord. On 23/9/2003, after surrender of the petitioner, thereafter the POCSO Act has been added.
Okay. Married.
My lord.
She-
She is a married lady. But in 161 and 164 statements,
So
My
that
lord,
is
my lord,
contradiction
I
is
may-
there.
My lord, as per the record available, my lord, the date of birth certificate is 2/1/2007 and the date of occurrence is 5/2 till date, my lord. But the date of occurrence, my lord, the victim was only 16 years. And also, my lord, the 164 statement is available. If your lordship may allow to me, I may read or.
Yes. No, 164. read it.
Yes, my lord.
You are 65-year-old.
Yes, my lord. He is the
My lord, I am saying, I am just reading, just relevant.
You are 65-year-old.
Yes, my lord.
Girl is 16. And
she is also a married lady. my lord.
Requested.
married doesn't mean that.
Requested that lady to, for the message, I am working from this. You come to help me for the message. And after message, when she got back to the.
My lord,
her
161
kitchen,
statement
from
I
that side,
completely
I give
contradictory.
only bail to those POCSO cases where the difference of age is very less. Young people, they don't understand what happened. They do.
My lord,
So
this
therefore, I give. Not that 65-year man and 16-year-old girl.
my lord, what happened in this
Purpose,
case?
complete.
164 statement and 61 statement
not-
completely contradictory.
I am not conducting
So
a
far,
trial.
that is matter of
I
medical.
am
trial.
not conducting a trial. From FSI, 160 statement is there. Your age is 65. The girl is 60.
My lord, your
You are
lordship,
not-
Nobody was there.
my lord,
By
it
the
is not
technically alone.
available. You see,
them.
kindly have a glance 164 statement.
Examination is over. When the charge sheet was filed?
Charge sheet, my
Charge sheet
lord.
was filed on 7/4/2023, my lord.
Yes, my lord.
7/4/23.
My lord.
And what is the stage of the trial?
That
Stage of the trial?
picture.
Stage of the trial. Trial is going on. What?
I have no instruction. I will obtain the instruction.
Regard being head to the fact that the petitioner is a 65-year-old man and the victim is 16-year-old girl and the offences are under section so and POCSO Act. I am not inclined to admit the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail application after the victim and material witnesses are.
Yes, ma'am.
Yes.
30.
My lord, in this case, police has not filed the final charge sheet till now. Final charge sheet has not been filed.
Victim is examined then. Yes.
Trial has not been commenced.
That's right.
Trial examination will be or something.
Your lordship,
Let the
kindly have-
victim be examined. Let the victim be examined. Or within, or with that 6 months ago, within 6 months, whichever is examined. Yes. You order for 6 months?
Please.
Yes, sir.
For petitioner is in custody since my lord 30/10/2023.
30?
10.
30, huh?
My lord.
10/23.
My lord.
Yes.
My lord, allegation of having in possession of 95 gram of contraband brown sugar.
95.
My lord, which is below commercial quantity, my lord. And
because the bail application was rejected by the learned court below on the ground that another similar 21B case is pending against him, in which this honorable court has granted bail to the petitioner.
Yes, what do you say? Less than commercial quantity.
Less than
The
commercial
other
quantity.
matter he is already on.
Two cases are there.
That is admitted.
Father directed me to obtain instruction. His mother has been died.
No, father.
So after instruction from the IO that is true or not. I obtained that is true.
Interim bail.
ना इंटरिम बेल वो पक्का ही नहीं है क्या किंतु मेरिट रे भी क्या
37 directly.
37 टा कमर्शियल क्वांटिटी अबव कमर्शियल क्वांटिटी के
What about the other two cases?
गोटे आगे ता थरे रिफ्लेक्ट हेची 47 बिहार ओडिसा 12 वर्ष तळे गोटे थिला मद केस तापर सेटा एटा हला नुआटा ता थरे रिफ्लेक्ट हेची आगे से ऑर्डर रिफ्लेक्ट हेची
केते? What is the recovery?
ता थरे 215 ग्राम हेतिला रिकवरी
Brown sugar.
ब्राउन सुगर
Go in interim bail for some time. In at least spare Orissa for brown sugar.
आगे से केस रे साक्षी हैला बेले आयो को जेरा कला परे एक केस आगे हेची आयो को जेरा कला परे एक केस आगे आयो देची सेम आयो I was conducting the trial आयो को जेरा कला परे एक केस आगे हेची से तो देखिले जेरा रे किछि आउ हेई परिबोनी इंडिपेंडेंट विटनेस टर्न hostile in that case. After that, he was taken to custody.
That is the case then.
8 मास रहिलाणी आगे 8 मास 10 मास रहिलाणी
from facility also they were paid. The allegation is the petitioner is he was in possession of
95 gram
95 gram of brown sugar,
my lord,
which is less than commercial quantity. The trial court has rejected the bail application because of the reason that the petitioner is involved in two similar cases. The one case pertains to which year?
one case pertains to my lord 2016 47A BR Odisha
16 under section 47
47A BR Odisha.
Bihar.
It is reflected in the rejection order page 9.
And second FIR.
Second is 2SCC case number 14 of 22.
Is the 12CC case number 14 of
22.
In the said case, the petitioner had applied for grant of bail, and this court, while order dated 19/12/2022, while allowing BLAPL number 8163 of 2023, had already admitted the petitioner on bail. In the said case, the petitioner was found in possession of 215 grams of brown sugar. Mr. 216 gram of brown sugar. Mr. Mishra, then counsel for the petitioner, submits that the present case is posted upon the petitioner by the same IO who is the IO in the case of in 2ACC case number 14 of 2023. This case is registered against after the IO of the aforementioned case was cross-examining the court. Cross-examining the court. So therefore, the IO out of vengeance has registered the case. The petitioner is in custody since 30th 2023, and in all other in other two cases where he has already been in the other two cases he has already been granted. Keeping in view the facts of the present case and quantity of contraband recovered, period of custody, granted bail with all conditions. You are
local.
Yes. Additional condition, no? Yes.
Urgent copy, man. Father died. Urgent copy.
Urgent copy. Father died. And Mr. Arjit, when he died?
On 9/8/2024. This is the
further
certificate.
Submit that father of the petitioner has expired on 9/8/2024, and he has relied upon the certificate
given by
the Sarpanch आपको सोमेपुर ग्राम पंचायत,
Sompur Gram Panchayat.
सोमपुर ग्राम पंचायत. Yes.
31.
May I please, Your Lordship? The case was registered on section 302, 341, 294, 323, 34 IPC, my lord. And the sources have stated that this petitioner, along with his wife, has assaulted the deceased, my lord. And Your Lordships, in the postmortem report, the doctor found that due to cardiac arrest, he was succumbed to injury. There is no external injury, my lord. And petitioner is in custody since, my lord, 12/11/2023, my lord. 12/11/2023, my lord. And wife has been released on bail by the trial court, my lord.
Sorry, who?
Wife has been released on bail in the meanwhile.
Okay. There are two accused.
Two accused, husband and wife.
And why? Where is that order of wife granting bail?
Wife is mentioned in the rejection order, my lord. Because of the lady and his illness, this petitioner also, my lord, ill. He was hospitalized, and the report was also called for, and report has been called. Report has been come, my lord, that he was suffering from TB, my lord, inside the jail.
Pack B is the report. Pack B. my lord.
Pack B is the report.
TB.
Pack B.
Flag B.
My lord.
Man.
There is no flag B.
What I'm noting is that flag B.
Report is there.
Flag C is there. Flag B. Where is flag B?
It has literally flag C. Another report is flag B.
You show me the medical
injury report, Your Lordship.
My lord, there is specific allegation assaulted by means of a bamboo stick. There is specific allegation.
Single blow.
No,
single blow.
My lord.
Proved to be fertile.
My lord, there is, my lord, specific allegation against the present petition.
But died due to cardiac arrest.
My lord, PM report is that, my lord. That is myocardial infraction, which is a natural process. And the doctor has given opinion, my lord. That is what is myocardial natural process, my lord. It is a possibility that acute myocardial infraction can be resulted in a person with predisposing risk factor of the cardiac disease following severe emotional stress.
In the case of single blow, turn to be fatal.
That is
fatal.
No external injury.
This is the
and he is suffering from TB.
That is correct.
So many things. Why should you keep him in the jail?
That is correct.
To create problem for other inmates.
Well, my lord, cardiac arrest, my lord, that is relating to, that is due to assault.
You read that. You read that part of the medical report which goes in his favor. The rest you leave it. Then only bail can be granted.
My lord, I'm not opposing that.
Right. Petitioner is accused in the FIR. Okay. Allegation is the there are two accused in the present case. Petitioner and his
wife.
And the wife has the co-accused, the wife co-accused has already been enlarged on bail. There was a report sought from the jail authority on the complaint that the petitioner has been suffering from and the report is placed on record in flag B, which indicates that the petitioner indeed is suffering from report dated 12/4/2004 filed by Superintendent District Jail Baleshwar is on record who has inter alia stated they look like we like handwriting 156 handwriting. The allegation against the petitioner that he has given a lathi blow to the petitioner to the victim who succumbed to the injury. It appears that this is a case, the postmortem report, however, indicates that death is due to
no external injury, my lord. There is no external.
It appears that this is a case of single blow caused by the petitioner, which proved to be fatal. Apart from that, since the victim was suffering from cardiac problem, he appears to have succumbed to the blow given by the petitioner. Since the petitioner is already in custody since 12/11/2023, co-accuse has already been granted, and this is a case of a single vote proved to be fatal. I am inclined to admit the petitioner on bail or subject to additional conditions, whatever it is. Yes.
Obliged.
32. And you write that the prosecution single glance. Yes.
May I please? My lord, the petitioner is a local man having no criminal antecedent, is inside custody since 24/12/2023, man.
24/12/2023.
24/3.
24/12/2020.
24/12/2023.
Okay. Yes.
My lord, and he has been charge sheeted for offense under section 376 and allied offenses 307, 323.
Show me 164.
Madam.
What is your
Madam,
age?
here the rejection of order was on 18/1/24. And
Okay.
charge sheet was submitted on 19/2/20. So
You
before
got to
joining-
vote.
and my lord 160.
That is standard order here.
There is the allegation is against the allegation is by a lady aged about 28 years old.
You are 35.
35.
I am 35.
What are the allegations?
Allegation that madam reading. And there is medical examination report is there, my lord, there is sign and symptom of sexual assault.
Well, I don't. Well,
After how many days? One, he's trying to help you out. After how many days the medical report?
My lord, medical examination is conducted on 28/12/23.
In
FIR was FIR was on 23/12/23.
23 FIR.
28 medical examination.
28 after 5 days.
5 days. Instead of that, my lord, there is sign.
Sign.
Yes.
Well, subject to your lordship.
You said no sign.
No, my
I
lord.
thought that he's
No, my lord. I say that
on the part of your lordship may kindly consider. May I place that 164 statement?
Read.
I will.
They were in relationship.
But I was in a relationship. I claim that, my lord. It is telltale.
But what she claims, that's important for bail.
But from her
If she
164.
says that I was in relationship, then you are entitled.
My lord,
You may say whatever.
My lord, I am obliged.
My lord, 164.
164 statement, may I place, my lord?
Yes.
I will try to demonstrate how the relationship has subsequently been given such a connotation, your lord. ମୁଁ ଆଜକୁ 7 ମାସ ତଳେ ହେବ ବୌଦ୍ଧକୁ ମୋ ମାମୁଁ ଘରକୁ ବୁଲିବାକୁ ଆସିଥିଲି। ଏଇ ଭିତରେ ମୁଁ ସୁବୁଦ୍ଧିଙ୍କ କ୍ଲିନିକ ଡକ୍ଟର କ୍ଲିନିକରେ କାମ କରିବା ଆରମ୍ଭ କଲି। ମୁଁ ମୋର ମାଉସୀ ଝିଅ ପିଙ୍କି ବେହେରାଙ୍କ ଘରେ ରହି କ୍ଲିନିକରେ କାମ କରୁଥିଲି। ପ୍ରାୟ 1 ମାସ ତଳେ ମୋତେ ପିଙ୍କିର ଦିଅର ରାମକୃଷ୍ଣ ବେହେରା ଦ ପ୍ରେଜେଣ୍ଟ
My lord, may I please? I'm appearing for the informant, my lord, in this case.
You have to face both the sides.
Sir, he has got the flavor last occasion where your lordship applied mind said you deposit substantial amount. In fact, 5 lakhs was pending with the accused to be given to the victim. Now he has got a check of only 1 lakh rupees out of 5 lakhs. Draft.
My lord.
My lord,
Whatever
it is not like that. It is not about money only. In fact, this is a tip of an iceberg which has come from the affair. This case is like the victim has been a victim of an app which is called Tango, which is banned in India, which is about some nudity app. There, this petitioner, along with another lady, was forcing her to get involved in feature in that app too, after getting married to the victim girl. For that reason only 7 lakhs was taken from the victim. Time and again, you invest, I'll get money from that. Then when the money couldn't be generated from that app, he insisted the girl to come and get featured in that app. So that is the...
He got, got featured, no.
No. When she denied, the other lady and this petitioner came to her house, threatened her before all the family members. Then only the family members could come to know there was a marriage and all these things have happened to her. After about 2 years, then the affair was lodged.
Now charge sheet is filed.
Yes, and the petitioner happens to be then, he was a provisionary officer in the bank.
After the rejection order, charge sheet was submitted.
Now you are not willing to accept that.
It is a meager amount, my lord, 1 lakh at least.
I'll adjourn it. You simply take it, I'll adjourn it. I am not saying anything.
Well,
I'll adjourn it. At least see, today or tomorrow he is entitled to bail.
Yes.
If I'll reject today, after 2 months or 3 months or 6 months, he'll get the bail. You are less, you know.
Yes, that is right.
So
at
least you get some money. He is entitled to bail today or tomorrow.
Yes, that's correct. But let her not suffer. It is like the suffering have been much more because she has come to light and told about this app and everything. So let her be also secured with some substantial amount, about 5 lakhs. She was working in a small banking company as well.
You are
small time.
My lord, 29/1/2024, more than
29?
one, about 8 months.
About 8 months is not a probationer officer and see the kind of crime you are committing.
She both are friends of aged about 29. She is a cashier and that present petitioner is a PO. But my friend is now submitting a new things. In the investigation, there is nothing about that. In the investigation, there is nothing.
Come to that. That is an affidavit I filed with all the documents.
Whatever story you have said.
Yes. Investigation.
Is reflecting in the
no 160.
Is it reflecting?
Even my friend he himself admitted that in 164 I have not started anything. Now I am because I have not started in 164 and 161.
That's correct. 164 she could not
And
because
only
of this app thing had not come.
If you don't say anything in
that will come in the trial.
Only to keep me in the bar, behind the bar.
I have given the documents
as per the suggestion of my friend and your lordships. I have paid to 2.75.
How much you have paid?
2.75, 3.75, my lord.
Out of 7.5 lakhs, he had paid 2 lakhs something. So 5 lakhs was pending and he has got 1 lakh DD.
There is a transaction. She is only saying, my mobile was kept by the police.
My
lord.
Both of you are bank officers.
50%. No, 50. Allegation, fair allegation, my lord, 3 lakhs something.
Pay
no, I am ready with, but my friend is telling about 7 lakhs.
You accept it, I'll take up next week.
My lord, next
Come
week.
with some money, I'll grant.
My lord, I kete bapa douche etaku. Au mu 3 lakh allegation FIR mu 3 lakh plus
You are a probationary officer. You wanted to make money out of this wrongdoing.
No, my lord. This is not a wrongdoing, my lord. My friend is creating a new thing, my lord.
Why should you go involved?
No, my lord. No, that is a fake allegation, my lord. In the investigation, there is nothing, my lord.
Why fake allegation against you?
Well, in case of they are both friends. On her own willing legs, he went to Calcutta to reside with the present petitioner. After 3 years, because of maybe there is some conversation or something else. For that reason, after 3 years, he is alleging against me.
You are married?
No.
You are already married.
No, not married to that lady. Married to the...
You are already married otherwise.
No, married to the victim.
Married.
Married. The
yes, that is a registration.
Registered
marriage, which she is.
Why are complicated? Let them stay together.
No, complicated. Khali,
Money, 5 lakh rupees is very important or marriage is important?
No, marriage, she cannot stay with him anymore because of this conduct. There is complete all evidence in the house of this accused.
Okay, see, if you want to take the money, you take.
Yeah, I'll take, but little more. He comes
A
from
little
very
more
good
behind
place.
paisa debi behind more rahim.
Please, no, I'll grant bail. You are taking.
My lord, marriage certificate during the investigation.
498, 376 and all.
ଏଥିରେ my lord 8 ମାସ ରହିଲାଣି.
The very
ତାପରେ
fact that it is 498A and 376.
Technically, it shouldn't go
my lord, investigation, the victim herself produced the
Counsel
160.
for the petitioner hands up a demand draft of rupees
1 lakh.
1 lakh, 1 lakh, which has been accepted by the counsel for the opposite party. Yeah?
Without prejudice, my lord.
Without prejudice. Without prejudice, leaves the matter.
My lord, I pray one thing.
Next week, yeah.
I have paid about 3 lakhs.
Next week.
Thereafter, my lord, I will remain in the custody.
Next, no.
Your lordship may kindly consider for.
Wait, next week I'm granting the bail. Don't worry. But
Today I am giving, but my lord,
today you give.
ସେ ନବା ପାଇଁ କେତେ ଆତୁର ଅଛନ୍ତି କିନ୍ତୁ ସିଏ ସେମିତି କଷ୍ଟଡିରେ ଥାଉ ସେଟା ସେ ନବା ପାଇଁ ଆତୁର କିନ୍ତୁ ସେ କଷ୍ଟଡିରେ ଥାଉ
Money has its own charm.
my lord, it is totally impossible for his father.
Money has its own charm. Okay, give it to him. Give it to him and try to get something.
But my lord, taking money and keeping the petitioner behind.
Keep it next week. I'll grant.
My lord, Friday fix.
Not Friday.
ପଇସା ଦେଇକିରି ଭିତରେ ରହିବେ.
Friday. Friday I'll lease it, but I'm not available.
No.
Therefore,
Unnecessary, my lord.
Tuesday, Wednesday. But
What is-
tell your client that the court is not inclined. Huh?
No,
So that he'll
no,
get-
I will not.
The medicine.
But he's entitled to bail.
My lord,
But in the same time, he let him persuade his client to give something.
no, I have persuaded. My senior Mr. Patnaik have persuaded. His father expressed his inability.
We'll see.
So,
Next.
My lord,
Next.
one thing I pray, my lord.
What?
They I suggested.
The next week I'm doing it. Next week I'm doing it. Yes. 34.
May I please your lordship? I am in the vision.
1 lakh rupees, there will maybe change of mind also. So she will be interested to stay with you.
And the father of the petitioner with a very sorrowful mind will go to home. He has a very expectation that, sir, with much difficulty I have collected the money and paying.
I know, assure him that next week he will see his son. We'll do it. 34. 34. Tuesday.
May I please?
Tuesday. Tuesday. Yes. 34. Yes. Learned senior will argue in this matter.
I am sorry, I am in the vision, my lord.
It's all right. Yeah. Yes.
This is a case where the petitioner was arrested on
4B.
3/1/23.
And
offense punishable
under 302, 498A, 304B, 4D.
charge sheet also.
That's it. That's it.
That's it.
Yes. Yes.
All the family members were robbed in this case, my lord,
Mhm.
and all other accused persons, they have been released on bail as per the direction of this honorable court. And the petitioner, the husband, and he is behind the bar. Charge sheet has been submitted.
Since he behind bar since
3/1/2023, lordship. 3rd January 23. 3rd January, my lord.
23. Okay. Okay.
And the allegation is omnibus in character. After the marriage, there is no allegation what sort of dowry was demanded. But I have filed the statement of some independent witnesses.
Yes.
Your lordship, may I have a glance to page 38. Annexure 4.
38.
Annexure 4.
Yes.
What was the dispute between the husband and wife that was in
How she died? Tell me how she died.
died, it is said that
1 minute.
asphyxia,
Strangulation.
and
this
it
confusion,
is
4 numbers
suspected
of
that
confusion
it
was
may
the
be
dead body.
homicidal death. That was the cause of death. On that point, I will add
Strangulation. Strangulation. Strangulation.
strangulation.
So therefore 302 is not 306.
Yes, exactly.
And he is the husband.
On that
The
point, I
discharge is child
want to
for
say
9
one
months
thing,
child.
one point.
9
9 months child is there.
Deceased has,
Home or delivered?
yes, she has already delivered. 9 months child was there.
Yes.
Actually, the child was suffering. Time and again, the petitioner was taken to hospital. On the previous day of the fateful incident, both husband and wife took the child to the hospital. The allegation of the husband is that the wife is taking care of the child, and that was the reason for the time and again illness. And that there is a quarrel while they were returning in a auto. That is the statement of the auto driver. So Lordship may kindly turn to
38 page you wanted to show me.
page 40, Lordship. 40, 40, 40. 40,
Okay. Okay, 40. Yes. Haldar Rao.
What is Haladar man?
Yes.
ମୋର ଏକ ଗାଡି ଯାହାର
ହଳଦର ରାଉତ ମାଇଲ।
ମୁଁ ନିଜେ ଆମ ଗାଁର ସୁରେଶ ଭୂତିଆଙ୍କ ତୃତୀୟ ନମ୍ବର ପୁତ୍ର ରତିକାନ୍ତ ଭୂତିଆ ର ବିବାହ ବାଛୁରୀ ଗାଁର ସାଗରିକା ମହାଗୁଡିକ ବୈଦିକ ରୀତିରେ ହୋଇଥିଲା। ତାଙ୍କର ଗୋଟେ 4 ମାସର ପୁଅ ଅଛି। ସେହି ସମୟରେ ଛୋଟ ପୁଅର ଦେହ ଭଲ ରହୁନଥିବାରୁ ସେମାନେ ମୋର ଅଟୋରେ ଢେଙ୍କାନାଳ ମେଡିକାଲକୁ ନବା ଆଣିବା କରନ୍ତି। ସାଗରିକା ତାର ପୁଅ ଦାୟିତ୍ୱ ଠିକରେ ନେଉନଥିବାରୁ ରତିକାନ୍ତ ତାର ଭାଉଜ ବନିତା ବେହେରାଙ୍କୁ ମଧ୍ୟ ସାଙ୍ଗରେ ମେଡିକାଲକୁ ନିଅନ୍ତି ଏବଂ ଅଟୋରେ ଫେରିବା ବେଳେ ଉଭୟ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ପାଟିତୁଣ୍ଡ ହୁଅନ୍ତି। 31/12/23 ଏଇ ଛୋଟ ପୁଅର ଦେହ ଖରାପ ଥିବାରୁ ଚିକିତ୍ସା ନିମନ୍ତେ ମୋର ଅଟୋରେ ଢେଙ୍କାନାଳ ମେଡିକାଲକୁ ଯାଇଥିଲୁ। ସେଠାରେ ଡାକ୍ତର ଦେଖାଇ ଘରକୁ ଫେରିଥିଲୁ, କିନ୍ତୁ ବାଟରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ପାଟିଗୋଳ ହୋଇଥିଲେ। ତା ପରଦିନ 1/1/23 ଖବର ପାଇଲି ଯେ ତାଙ୍କ ରତିକାନ୍ତ ଭୂତିଆ
What are you against you?
quarrel
What are you trying to show me? There is a quarrel and the child was not well. You are not happy with her because she is not taking care of the child. This is the independent witness.
That is the case, but not it is a dowry death case. I want to place, so far the murder is concerned, your Lordship put me the question. I humbly submit that it may be a error on the part of the PM doctor. They have opined in a haphazard manner. The opinion led to say that death was due to asphyxia as a result of strangulation, which was mostly homicidal in nature. That was the opinion. And basing on that, the allegation and label against all the family members, they murdered the deceased, and all other accused persons are released on bail. And
strangulation is done by the husband. So the other members are granted bail because of that.
No, your Lordship may see the last line of informant statement which I annexed and the mother statement. There are 2 witnesses, that is the mother of the deceased and brother of the deceased. I annexed both, your Lordship kind perusal.
Yes.
Complainant is the Kartika Chandra Mahakurma.
Kartika Mahakurma.
I'm reading that portion.
Yes.
ଆଜି 1/1/23 ବୟାନ ହେଇକି ଯେ ଗତ 7/7/21 ମୋର ଭଉଣୀ ସାଗରିକା ମହାକୁଟର ବିବାହ ପୋଡପଡା ଗ୍ରାମର ସୁରେଶ ଭୂତିଆଙ୍କ ପୁଅ ରତିକାନ୍ତ ଭୂତିଆଙ୍କ ସହିତ ବୈଦିକ ରୀତିରେ ହୋଇଥିଲା। ବିବାହର ପରଠାରୁ ମୋର ଭଉଣୀକୁ ତାର ଶାଶୁ ଶ୍ୱଶୁର ଲୋକ ବାରମ୍ବାର ଶାରୀରିକ ତଥା ମାନସିକ ଭାବେ ନିର୍ଯାତନା ଦେଇ ଆସୁଥିଲେ। ଆଗରୁ ବହୁତ ଥର ତାର ସ୍ୱାମୀ ତାକୁ ମାରପିଟ ମଧ୍ୟ କରିଛି, ଯାହା ଫଳରେ ମୋ ଭଉଣୀ 1/5/2023
Then you have to wait till the material witnesses are examined.
My lord,
you have to wait till the material witnesses are examined.
There are 2 material witnesses, my lord, in this case.
I'll direct the trial court to give preference to examine these 2 witnesses.
My lord.
Right. The petitioner is agreed by the order dated 5/10/2023, whereby his bail application has been turned. There are Mr. Mahapatra and senior counsel appearing for this appearing for the petitioner submits that all other granted bail. The allegation against the petitioner is that he was the husband of the deceased. The deceased has been strangulated by him, as a result of which the homicide death was caused. After investigation, charge has been filed and the matter has already been committed. I'm not going to the type of allegation against the petitioner. I'm not inclined to enlarge the petitioner on bail at this stage. however, liberty is granted to petitioner to renew his bail plea before the trial court after the examination of the material witnesses. There are two material witnesses, Mr. Mahapatra.
Two. Mother-in-law and the brother-in-law of the petitioner. That is the mother and brother of the deceased.
Doctor also. Mr. Mahapatra, land counsel for the petitioners, states that there are two material witnesses, namely the mother-in-law and father-in-law for the present petitioner. And since the medical evidence is also crucial, the doctor is a material. Doctor is also a crucial evidence, crucial witness to the prosecution. Therefore, the trial court is directed to give preference, preferentially examine the material witnesses, namely mother-in-law, father-in-law of the petitioner, and the doctor in the present case over the other formal witnesses. And 6 months. Either 6 months or material, whichever is earlier.
One thing, my lord, may I mention another matter. Weekly list item number 27. That is hearing. Yes. I may not available in this week, so I pray that it may take next week.
Okay, note 20. Yes. Okay.
35.
Yes.
The prosecuted offence under section 498A, 304B, 305 PCL also.
Yes.
The petitioner is in custody since 10th of August 2023.
10th August, huh?
Yes, Your Lordship. The final form sheet has been
Sir,
submitted
yes.
December 2023.
7th December
Yes, Your Lordship.
23. Okay.
And here in
In
this
charge
case,
sheet, what are they?
My lord, the rejection order, it was 1/24. That the case was posted for evidence from the side of the prosecution. So he has to take instruction how many witnesses were examined.
This charge.
yes, my Lord. Some of witnesses
The
examined.
trial in the present case is progressing, and the trial court was supposed to examine the witnesses. When counsel for the petitioner seeks an adjournment to obtain the instruction for the trial, please the matter. Yes. 36.
Obliged.
Yes. 36.
I may be permitted to submit by virtual mode, my lord.
Yes.
May I please the lordship? My lord, the offence alleged is under section 20B2C of the NDPS Act. And the prosecution case is that, my lord, at the time of raid, nobody was there in the house of this petitioner, and they have obtained a huge quantity of ganja from the house of the petitioner, and that house is recorded in the name of the petitioner. That is not correct, my lord. In fact, my lord, the house that house is situated over plot number 408, and that the record of right is recorded in the name of 9 brothers, my lord. And all of them were residing in the house at the relevant time, except the present petitioner.
This is an ancestral property.
My lord?
This is an ancestral property you are saying.
Yes, my lord. There is no other house of the petitioner.
Okay. You are in custody since?
My lord, 2013.
My lord, 8/2/2024.
You final prosecution has filed, PRs was submitted in 2013, made, showing the petitioner as absconded. Subsequently, NBW was issued. On the strength of NBW, was arrested on 8/2/20.
Your conduct is so bad. 2013 matter, you absconded. How will you get the bail?
My lord, the petitioner is added about more than 80 years.
80
and
years?
is unable, 80 years, more than 80 years, my lord. And he is unable to work or do his daily work regularly, my lord.
No. I'll grant me. 80 years. What is the recovery?
150 kg ganja.
Recovery, they said that huge quantity of ganja.
Okay.
Which cannot be correct, my lord, in view of the record of right.
8/2/24.
8/2/24.
2024, my lord.
Yes, petitioner is accused and so on.
My lord, may I pray, I will produce that record of right, my lord. Standing in the name of all the nine
Sir,
brothers.
please wait. I am granting bail. Don't worry. I am granting bail. Please wait. Let me dictate the order.
Sorry, my lord.
Yes, because of the reason that yes, you are 80-year-old. Otherwise, you are not entitled to bail because owing to your age, I am giving you. Yes. The petition is accused in apparently. Alone?
The final PR was only, it was written in the rejection order, the final PR was submitted.
In the year
showing the petitioner is absent.
Since the prosecution alleges that the petitioner has been absconding. Therefore, the final PR was filed showing the petitioner is absconding. The allegation against the petitioner is that 105 kg of contraband ganja was recovered from his house. Mr. Gopal Mahanti, learned counsel for the petitioner, submits that this has wrongly arraigned him as an accused on the ground that the house from where the ganja was seized belongs to him. In fact, the house is an ancestral property. Ancestral property of belongs to 9 of his brothers, 9 of his family members, 9 of his family members. Therefore, the allegation of the prosecution is completely misleading. Completely misleading. The petitioner is in next following. The petitioner is in custody from 8 to 2024. At present, the petitioner is 80 years of age. Going to the age of the petitioner, now regard being had to the age of the petitioner and period of custody and the nature of allegation leveled against the petitioner, I am inclined to admit the petitioner on bail. Accordingly, the petitioner is yes.
37.
Yes, I have granted bail, sir.
Yes, sir. I'm not late, my lord.
Yes.
May I plead your lordship?
Yes.
The petitioner forwarded under section 363, 366, 3736 to an IPC read with section 6 of the POCSO Act. Petitioner is in custody since 29th January 2024. Charge sheet has been filed on 28th March 2024. My lord, there is a love affair between the petitioner and the victim. The victim has been rescued, and after rescue of the victim, the offense turned to 63, 366.
1 minute. Sir, your bail application is rejected on 26 February 2024. Isn't it?
My lord.
Your bail application is rejected on 26th of February 2024.
My
and
lord.
Charge sheet is filed subsequently. So you
My
have to
lord.
go to the trial court first. Right on. Petitioner is
My lord,
agreed by the.
my lord, one thing. My lord, I have filed the charge sheet, my lord.
That's right. I know that 26 to 2024, whereby his bail plea of the petitioner has been rejected. Now, first paragraph will be subsequent thereto, on 28/3/2024, the police has filed the charge sheet in the present case. Therefore, the petitioner, I am not inclined to entertain this petition at this stage, owing to the fact that the bail plea was made by the petitioner at the time of investigation, during the investigation, and subsequently, since the charge sheet has been filed, the petitioner should approach the court of first instance. With this liberty, the petitioner is disposed of. Yes, next.
38.
Next.
The petition in custody since 15th January 2024, my lord.
15th
January, 15/1/24.
Yes.
For the, and in charge sheet section 306/294.
Yes.
My lord. And the fact of the case, my lord, the petitioner and the deceased, my lord, their cousin, my lord, the petitioner is the brother, my lord. Both are labor class, my lord. They have done a work, my lord. They getting the deceased was received 300 rupees from the owner, my lord. But it could not pay that amount, 150 rupees, to the present petitioner. For which the present petitioner being the brother-in-law of the deceased, my lord, he said କାଇଁ ମତେ ପଇସା ଦଉନ ମରି ଯାଉନ କାଇଁ ରହିଛୁ thereafter she has committed
Charge
suicide.
sheet was submitted on 29 to 24.
You should file a quashing.
But the eyewitness
And you
was
know a judgment, Supreme Court recent judgment, Justice, I think, Justice Bikram Nath's judgment. It says that in that case, even if the accused has said that go and die, and thereafter immediately he dies, 306 is not made up.
but this case is like that. Only
Exactly.
What you are talking about bail is not made out.
But
It's not made out.
I will check up that.
The husband said the wife has been telling that I'll die. Then she went and died immediately after. The husband says that go and die. I don't need you. She goes and commits suicide.
no, in this case immediately yes,
And no case is under 306 is made.
But like case is that
It's
was
similar, exactly similar.
eyewitness stated that.
Granting. Yes. Tell me where are the
My rejection order is 26 to 24. Then after charge sheet was submitted on 29 to
29 just because
case is not made. The petitioner is getting the allegation against the petitioner is in nutshell, the allegation is that the petitioner did not return the money he owes to the deceased. When he demanded the money, the petitioner appears to have said that let him die. On that instigation, the petitioner appears to have committed the suicide. Petitioner 15/1/2024. 15/1/2024. Regarding to the nature of allegation and the period of custody, I am entitled to bail. Yes. Okay. What's his name? Yes.
May I please, your lordship?
Madam 39.
Yes, sir.
That matter I want that I will take instruction whether the charge sheet was submitted or not and
Yes.
whether the viscera report was.
After. Yes. Next.
Obliged.
Item 40, my lords, arrest is on custody since 7/6/2023, my lords.
7/6?
23.
Yes.
And charge sheet is on 3/8/23.
3/8?
23.
Okay.
Allegations are under 376(2) and 2I, reading section 92 of Right of Person with Disability Act.
Yes.
Your my lords,
Disabled girl.
my lords. Victim is major and more than 2 years senior accused
Maybe
person.
she
7 years,
disabled.
7 years pregnant, she was there at that time.
7.
She's a disabled girl.
7 months.
There
What
is a
is the
violation,
disability?
my lords.
90% is there.
No, what kind of
There
disability?
is no certificate even prove that, my lords. There is nothing
What
in
is
about
the nature of disability?
Nature of disability.
right leg टा same the T top रे चालुଛି, my lords. Fingers ଉପରେ ପୁରା full step ଟା ତାର ପଡୁନି.
What are the allegations? 164.
The charge sheet is not with us, but 164 is charge sheet is not with me, but 164 is with me. By
Get the charge.
yes,
CD call.
yes.
Yes. Next.
41.
Call proceed. Yes.
Please, your lordship. Here, the petitioner is in custody since 14 to 2024.
14 to
2024.
Okay.
The offense under section 417, 493,
Yes.
313 IPC.
Hmm.
The victim is aged about 30 years.
30 years.
My lords. She having love relations since 4 years, my lord. As admitted in your 161 and in your statement, my lord.
What are the allegations?
So here also charge sheet is not.
Hmm?
CD charge sheet is not.
Let's call for CD. Next week. Yes. Yes.
42.
42 also same lordship charge sheet is not.
Call for CD.
102 gain.
CD.
Similar 43 is also.
43. Let the CD come.
Yes.
43 also. Huh? Call for CD. Yeah? Yes. 43. CD. 44.
44.
He'll give a date. Don't worry. Within a week. Don't worry.
May I please, ma'am?
In all matters, you will get the dates. Yes.
May I please, ma'am?
Yes.
But the petitioner is the mother-in-law, my lord, aged about 60 years, my lord. And she is inside custody since 8/11/2023.
302.
302, 304B, 498.
Charge sheet filed.
Charge sheet already filed. The husband is also inside custody, my lord. He is the prime accused. The mother-in-law, because of the omnibus allegation, the mother-in-law is also arrested. And
Not husband is the prime accused, mother is the prime accused.
Okay.
Husband was in outside. It got here at the time.
of
Yes, occurrence.
তাহলে হাজবেন্ডের বেল পড়লে আর সে কইবে তাহলে হাজবেন্ডের বেলটা হবে
You are saying if prime accused, you are saying. What I can
And
say.
you file both the applications.
Yes. The husband bail will come after tomorrow or Friday.
Obviously, this is the truth that I have to say.
Let it come there.
Obviously, I have to say the truth.
And let the husband's application. You have filed it already.
Yes, yes.
It is there. Give me the number.
Number I will.
Huh?
সেটা আপনার পাখের মধ্যে আসিওনি।
Okay, then wait. Okay, after 2 weeks. I'm leaving this week, next week. Yes, simply example.
লেডিটা খালি husband against ଅଛି strangulation allegation ଅଛି husband against.
Husband was not there at all.
I was
Who is
not there.
strangulated? That's what he says.
Husband
Husband was not
at
there.
the time. After getting the phone call, only he returned to from Kotak to there.
So then strangulation. Then you are in danger zone. Mother-in-law. If husband would have been there, then all strangulation allegation would have gone to him.
My lord.
Wait. If husband gets the bail, you may get parity.
My lord.
Wait.
My lord, may I?
Adjourn after 2 weeks.
My lord, may I pray, my lord, item number 65.
Yes.
It is the bail was moved before the learned court below prior to submission of charge sheet. POCSO. In the meantime, charge sheet has submitted. Lordship may grant liberty. I will move again.
64.
65.
65. Mr. Mishra, learned counsel for the petition, seeks to withdraw the present petition. Plea before trial court.
As charge sheet has been submitted.
As charge sheet has already been filed in between.
Right. Oblige.
64. Yes.
45.
If I want to pay for POCSO,
POCSO. 46. 46. Nobody there. Case diary came.
Yes, sir.
What is the offense?
302.
302.
Yes, sir.
Yes, please come.
46, Lordship. In case of 302, and Lordship, look at the age of the petitioner.
70.
70 और मामू भंजा भीतर dispute, Lordship. Sudden provocation.
What are the allegations?
Allegation is well proved, Lordship. Koti there, Rex there, and all these.
Well proved man.
Obviously on the.
ମାମୁ ଭଉଣୀ ଜମି ବାଡି ଝଗଡା ହଠାତ୍ ସଡନ ପୁରୁଷ ଲୋକ provocation ଦେଇଛି. That is only already in custody. ସେତିକି issue ସେତିକି ତ.
Witness?
Yes, witnesses are there. Eyewitness.
How many eyewitnesses?
2 eyewitnesses.
No, ସବୁ examined.
Akshay and
you are in custody
since Lordship 6/5/2023, Lordship. More than one.
Eyewitness, how many were?
2 eyewitnesses there.
Let them be examined.
ସବୁ examine ସରିଲାଣି କିଛି ନାହିଁ ଖାଲି ଆପଣ
Examine. Eyewitnesses have already been examined.
ସେ ସବୁ
I don't know.
ସବୁ ସରିଲାଣି.
They turn hostile.
Hostile. ସେ କିଛି
Where are they?
ସେ ଆଣିନି ଖାଲି ସେଟା ଡାଇରେକ୍ସନ ଦେଲେ ବି ସେ କଣ ସେ କହୁଥିଲେ ସେଠି ବେଲ ହେଇଯିବ.
Write down.
ଏ ଅଛି Lordship ମୋର ଅଛି.
ନାଇଁ, place it on record then.
କି eyewitness କିଏ କହିଲେ?
ଅକ୍ଷୟ ଆଉ ଦେବାଶିଷ, wife of the deceased.
Place it on record. I'll just see.
Lordship.
Please, Mr. Dalai and counsel for the petition seeks 1 week time to place on record the additional document to substantiate the case.
I mean, city direction is so close. Lordship, may I pray one thing, Lordship? With such objection, Lordship, remind I will move there, Lordship.
That is it. That's right. Mr. Dalai and counsel for the petition submits that. In the meantime, the eyewitnesses in the present case is
Lordship, principal witnesses, Lordship.
And principal witnesses. Material witness.
Material witness. Material witness.
Of the prosecution has already been examined. In view thereof, he seeks to withdraw this petition to renew his bail plea before the trial court. If such application is moved by the trial court, moved by the petitioner before the trial court, the same shall be considered on the available evidence on record.
Yes. So looking into the age and period of detention,
and keeping in view the age of the
age and period of detention.
Age and period of detention.
Let's get
of the petitioner since 6/5/2020.
23. Let's get for that.
47.
My lord, I am in virtual court, madam.
Yes.
The petitioner is in custody since 9/11/23.
Yes.
The petitioner was charged under section 376(2) 506 IPC and 66 and 67 of IT Act.
Yes.
Meanwhile, 4 witnesses are examined.
Then you renew your bail plea there in
Yes.
trial court. Then counsel submits that in the after the rejection of the bail plea by the trial court, material witnesses have already been examined by the trial court. In view thereof, he seeks
No
to
material witnesses,
withdraw the
only independent witnesses are examined.
independent witnesses have been examined, and in view thereof, he seeks to withdraw this petition to renew his bail plea before the trial court. Hence, the petition is disposed of as withdrawn with the liberty to the petitioner to renew his bail plea before the trial court. Yes, next.
48.
Custody since lordship 23/8/2023 lordship. Date of occurrence is lordship 5 August 2023.
What are the allegations?
Lordship, initially FIR has been lodged under section 341, 394, 323, 354, 503.
Charge sheet.
Subsequently, lordship,
302.
filed under
302.
302 and 34 IPC lordship.
What are the allegations?
Two items there.
And when the charge sheet was filed?
Charge sheet filed lordship
23
18
August 23.
18/11/2023.
Yes.
18/11/23.
18/11 lordship.
What are the allegations?
Lordship, there are 2 eyewitnesses there who has seen the occurrence.
May I draw lordship? Initially, lordship, what happened, lordship? Deceased and the sister of the present petitioner, lordship, there is a quarrel, and the present deceased lordship assaulted to the sister of the informant, sister of
All
the
these
present
things are
petitioner.
defense. What are the allegations you tell me
Lordship,
against you?
as lordship, cause of death, lordship, lordship, due to septicemia and cardiac arrest, lordship. As because lordship, the present petitioner and the other co-accused, lordship, as per the prosecution allegation, lordship, they assaulted the deceased, lordship. Assaulted by means of X, and the present lordship,
Yes. Recovered.
lordship, the present petitioner assaulted by means of lathi, lordship, on the right hand, lordship.
How many accused are there?
2 accused,
Two
lordship.
accused there.
So the so far as present petitioner lordship assaulted to the deceased lordship on her head, lordship, on her hand, lordship, left hand, lordship, and so far as other co-accused person, lordship, he assaulted by means of X, lordship. And so far as injuries, lordship, initially, as because there is a as reveals in record, lordship,
today
after
septicemia and
15 days, lordship, it turned septicemia and he died, lordship.
Yes.
So the intention, there is no intention to kill, lordship.
What I mean, head injury there.
Out of fun you attack.
Lordship, I have not attacked, lordship. The present
Out of
petitioner-
fun you have done. There is no intention.
The present petitioner have no intention, lordship. As so far as assault party is concerned, lordship, I have
You
not
have
assaulted.
given 34 is there. You have given lathi
No doubt,
blow
lordship.
along with the
Lordship.
co-accused who has used axe.
Lordship,
What else you need?
it is on the lordship, it is happened, lordship. And so far as present petitioner, he has no intention. So far as assault is part, concerned, lordship.
I think you renew your bail plea after the eyewitnesses are examined.
Yaar role lordship ki nahi actually, in fact, yaar role
Eyewitnesses are there. That's the whole difficulty. Otherwise, I would have granted bail. Eyewitness is
Principal offender is lordship.
307 converted to 302.
Initially, also-
323 initially
323.
323.
the injury is simple in nature, lordship. It was simple in nature, lordship.
Right.
But
What
the
is
Record, their
Lordship.
record says, lordship.
Six.
Septicemia
No,
has
Lordship.
become
What is the
increases.
stage? Now, the stage is
Trial is
Already
not
charge sheet filed. Charge sheet filed,
trial is not started.
not committed also.
I'm not.
Not committed.
more than 1 year. I mean,
No,
You seek instruction. What is the stage of the trial? Huh? According
Lordship, only Lordship directed that after the
no, it
eyewitness.
is not. Even if whether it is committed or not, after committal, then charge will be framed. There are
Lordship,
many
Lordship.
stages. Therefore, I want to know what is the stage. Accordingly, I'll fix the time. Right. The state council is directed to issue instruction getting them for the trial. Is the matter of 2 weeks. Yes. 49. May I take?
For case and postmortem report, or more chances required, my lord. That
1 week. Let him get. Yes, 1 week. 50.
The petitioner is in jail custody since 22/12/23.
Yes.
Petitioner has been charge sheeted offense under section 498A 304B 306. This is committed suicide inside her bedroom.
How do you think that I'll decide your bail application without there being any FIR, without charge sheet, without
Charge sheet already filed.
filed? When this court is not entitled to see charge sheet also, not entitled to see FIR also. You have accept the rejection order. You have not filed it.
As mentioned, charge sheet already filed, but clearly mentioned in the rejection order.
I'll write charge sheet has been filed, so therefore grant bail.
No, record has come.
You have to file at least something.
Record has come.
Record has come, then FIR नहीं, कुछ भी नहीं. Huh? In this matter, there is a letter change the counsel.
Yes, I do not know, Your Lordship. I do not know.
From the jail it has come.
prisoner petition, my lord.
He doesn't want, why should you take that? Huh? The letter has been received by this court from the superintendent of DC jail, Bhavani Patna, wherein the accused in custody has desired to change his counselor. The problem is it ଲେଖା ହେଇଛି ତାଙ୍କର ଏଭଳା ଯୋଗୁଁ ଓକିଲ ଶ୍ରୀଯୁକ୍ତ ଜ୍ଞାନ ପଣ୍ଡାଙ୍କୁ ମୋର କେସ୍ ଦେବା ପାଇଁ these people, those who are in jail, they don't understand the pressure of the court. They think that the lawyer is responsible for not getting the matter listed. What to do? They don't understand. They think that I have moved the application, the lawyer must be doing it. He doesn't want.
Yes.
Take it in record and list it. And Gyanapanda, who is Gyanapanda? Has he given? No. And in this process, again, it will be delayed.
Urgent this matter.
Simply urgent. Take it on record. Simply urgent. But you be there if the other counsel doesn't come, help this court to dispose it. And if you have FIR and all, please file it. Huh? 1 week. Take it on record, whichever it is. Okay. 51.
May I please, Lordship? The petitioner is inside custody since 8 February 2024.
8
February 8/2. And the
24.
offense is of 2N and 417. On the pretext of marriage, relationship build up, and in the meantime, there is a child born out of the said relationship.
Oh.
My lord,
POCSO is not there.
POCSO is not there.
Yes.
Victim is 21 years old.
762N is there. Charge sheet submitted, my lord. 417, 317.
No. they are married, there is a child,
My lord.
And,
That
and
is there in
thereafter
case record.
allegation.
Case record is there, allegation is there, my lord.
and he is disputing the legitimacy.
I am
of the
reading the
child.
164 statement, my lord.
Right. Read that.
My lord. ମୁଁ କବିତା ସୋରେନ 25 ଡିସେମ୍ବର ଭୂପତ ଗାଁରେ ବଲ୍ ଖେଳ ହେଉଥିଲା ସେଠି କନେଇ ବନ୍ଦର ଚନ୍ଦନ ଖଡ଼ିକା ମାର ପିଟିସନର ନାଁ ସହିତ ମୋର ଦେଖା ହୋଇଥିଲା ସେ ମୋତେ ତାର ଫୋନ ନମ୍ବର ଦେଲା ମୁଁ ଫୋନ ମାରିଲି ଆମେ କଥା ହେଲୁ ଗଲା ବର୍ଷ ରଜ
Test was sprayed on 21 to 2024. That report may be called for. That has
DNA
been
test
done.
report has come.
No, my lord. That medical examination report is there, my lord.
Medical examination that pregnancy is there, but DNA test.
And if you doubt the legitimacy of the child, then you have a difficulty. Otherwise, would have got the bail.
After examination of the victim, my lord.
That report may be called for.
DNA report, you have sought for DNA.
My lord,
It was sprayed before the trial court. And that may be.
Counsel for the petition submits that the prosecution has sought for a DNA report of the child alleged to have been born out of the relationship between him and the victim awaiting the DNA report, release the matter after 2 weeks. Yes.
One judgment I'll cite that
let it come first.
Lord, 96 maybe some other date, my lord.
96.
Item number 96.
Note karo, please.
With matter, I have another connected matter, another person is there, but
no problem.
Lordship,
some other date.
106 the.
I'll come. No.
Because I've got other matter.
Yeah, for you.
Whatever it's it,
My lord, 780. My lord already referred this matter before the mediation center. Before the mediation center, already matter amicably settled between the parties.
Report has come.
Yes, my lord.
70.
78.
I'll take it up. 78, I'll reach. We will reach that. I'll take it up.
Obliged.
Already because of the single appellant has died. Lordship. We have filed an abatement petition, Lordship, for the.
Let it come. I'll abate the set aside the abatement. No. Let it come. Yes. Whenever it comes. Yes.
Item 10. Please, Lordship. My lord, it's an order. This revision is directed against the order refusing discharge. My invite to Lordship.
Refusing what?
Order refusing discharge.
Discharge
Application. It's under section 7 and 13 of the PC Act. May I invite at the outset, may I invite Lordship's kind attention to the impugned order where the learned trial court has put an exercise.
Okay. Next week. Yes.
My lord, I beg your lordship. Today, my lord, the date is fixed for framing of charge. Your lordship say, my lord, we will make an application. I frame it.
No. Today, whatever was supposed to happen might have happened by now.
No, my lord. No, after lunch. Yes, my lord.
You simply tell that the matter is urgent.
Yes.
Or the request of
Yes.
Next.
Oblige, my lord. Oblige.
Yes.
No, my lord.
Not tomorrow. Next week. Tomorrow is very tough.
Oblige.
Here, the petition before my lord is in custody since 11/1/2003, my lord.
11/1/2023.
My lord.
Yes.
My lord, on being charge sheeted for the offences under section 498A and 302 of the Indian Penal Code, my lord.
So the instruction reflected that I have honored to be submit that as per the instruction received from the state honorable, it was assumed that the case is in this trial stage by the city case number 324 by 2023.
Trial has not.
Trial, so obviously it is a trial. Hey, what is the witnesses are examined? What are the
Witnesses have, trial has not been started, I thought. Not
charge is framed? Huh?
Charge has been framed. Well, initially, when the accused was arrested on 11/1/2023, well, he was forwarded to 306 of the Indian Penal Code.
Charge sheet is filed in 302.
So, charge sheet has been filed under 302.
No, but the FIR is also 302.
Yes. But because he committed suicide, my lord may kindly see, my lord and friend can see the case diary. The initial observation of the investigating officer, after verification of the spot, he is having an opinion that she has committed suicide. But he made a query from the doctor. Doctor has opined that it's a case. It may be a case of strangulation, for which yes, 302 has been registered. Yes, in the postmortem report says cause of death is due to combined effect of asphyxia and venous congestion. But above mentioned pressure abrasion is due to strangulation.
Yes. They detected around the neck. It is antemortem in nature and mentioned pressure abrasion is due to strangulation. The cause of death is disease due to the combined effect of asphyxia and venous congestion. So MO point that all
venous congestion because of the strangulation.
Well, when the IO went to the spot and made a confidential inquiry,
that the doctor's evidence supersedes this.
Doctor evidence is the opinion, man.
But IO is also superficial opinion.
That
how IO will tell whether it is a strangulation or what?
Because Ballard, he examined the spot, found that the body was hanging above 9 feet of the base, and
that might have happened after strangulation also. What is the
no, Ballard.
First strangulation, thereafter hanging or what?
No.
They found hanging.
It's not there. Ballard, as because he opined as such, because deceased has sustained 2 injuries, abrasion of the size of 2 inch into half inch over left side forearm, medial aspect of forearm, and bruise over right side arterial aspect of the hand. And 3, abrasion.
Any suicide note, anything?
Ballard?
No suicide note.
Suicide note?
Suicide notes, no.
It's not there. But an allegation is consistent to the effect that the petitioner is a drunkard. And because of that, she was not satisfied.
It also associated to the decision.
But it's not in the real sense of the term 498.
Because the doctor's evidence is creating problem for you.
Yes.
Let the doctor be examined.
Trials are so doctor examined.
I'll direct the doctor to be examined first.
Information.
I have awaited. If delivery comes, then remove application 394. We'll see.
Submission the last material on site.
After week of. But yes, he has to be, because what? Fine. Other accused. Other accused, along with that. 77. Yes. 46. Okay. Yes, that's about the items 97. 97, huh? Corporate matter, and I'm giving you that's appearing for the other side. Sometimes department, nobody has come what to do. No, see, they don't know whether it will be taken out of them. Just ask your junior to call him in absentia ex parte.
That I'm not in. Okay, the process kind permission. Can't pay. If they won't come to what pay, or they are in difficulty. And it be over on the first time.
Yes, but I hope that they will come today. Let us please wait. Let us see. If they come, I'll do it today. You tell your junior to just call. Whenever they come, any of them will come. Right. Yes. Only come. Oh, that I know. The lady. There were 3 petitions. One I allowed, 2 rejected. Three is not on. Same up.
Not only any alert. It was from position. Only allegation against him, he already gotten 580% for decision. It's not valid.
Allegation against the lady is also the same. I gave the bail for 2 reasons. One is the lady, and there are 2 children.
From this, nothing was.
Any allegation that okay. Same order. The connected matter today. No, that is the deed of connected matter. Same order. And when he then just see. Want to take it up? Okay. Urgent. Take it up. If you let him take it. Yes. So, again. It up if something is there, then we the accused was criminal came with a pistol. Yes, and the lady had called for a settlement of the partition, right? And in custody since 2024. Allegation is that having 50 kg ganja in his car. 50. Regulatory provision for 150 not complied with. Yes, what do you say? That will be a condition. Criminal indication there in 37 counts. File an affidavit. Petitioner application will seek 75 and affidavit regarding his, regarding the incident. That is file an affidavit, stating out the particulars of the case and the status of the cases against him. Yes.
Yes, so 57 taking out of this incident manner. What is happened?
Two different accused.
No, same accused. One incident, two cases.
You are capturing both the cases.
Both the cases. Since January 2024. January 24. There was a document in the 2018, from 16 to 2018, and FIR was lost. One, and the FIR is registered under section 363, the missing of his son.
Yes.
Then he was progress in the inquiry. He was filed the petition before this honorable court to transfer the investigation to the crime branch. Accordingly, it was transferred to the crime branch. Crime branch submitted his final file. Mistake of fact. Two of the break is last paragraph. The investigation and postmortem report, it is clear that the death of deceased was due to antemortem drowning. There is no such foul play regarding the death. So I return the case is a mistake of fact. And the FIR was registered against one person.
So thereafter what happened?
Therefore, the informant filed a protest petition.
How many days is taken?
This is this case.
What about the other case?
Others also in the same incident, two persons are missing. One is the present case and the other person, the item number. Then the two FIR were registered.
And both of them died.
Both of them died. They both was dead.
In that case also, closure report.
Report by the client. If in the protest petition, the witnesses who had been examined said that the present petitioner confessed before that. It is the extrajudicial confession.
Yes. What do you say?
My lord, in this case, I am appearing for the informant, your lordship. My lord, in fact, the case relates to murder of teenagers, your lordship.
Right. What is the case is? FIR was registered. On your request, it was transferred to crime branch. Crime branch investigated and filed a closure report saying that it is drowning. In the case of drowning. Okay. Thereafter, you filed a protest petition. Yeah, I mean, witnesses have only said that he has confessed, extrajudicial confession, and that basis cognizance is taken.
My lord, extrajudicial confession coupled with last scene theory, lordship. Last scene theory is also there, my lord. The lordship may kindly have a glance.
How will you discover finding of the police says that the anti-mortem drowning?
My lord. My lord, that was sent for chemical examination report also, my lord. That was sent for chemical examination, and the report also say the chemical examination report says that though diatom was present at the pond, but it was not detected in the sternum bone of the deceased. My lord, that itself.
All these things are has to be tried. But once the police investigate and say that the case of drowning, and there is no suspicion of foul play regarding the death, then at least he is entitled to bail, if not anything else.
But my lord,
when you prove the case, convict him, that is a different story. But he is not entitled to bail in this kind of facts.
my lord,
Yes, sir, what do you say? How is in custody? And this is in custody from 16/1/2024. And this is what is the story. On the protest petition, how far you What do you say?
That apart, the petitioners had approached before this honorable court in 2020 for an anticipatory bail under section 438 of CRPC. Therein direction was given to surrender and the bail application will be taken up on its own merit.
These are neither here nor there. Now, they are seeking regular bail, and these are the facts. How will you get over the independent investigation by the crime branch at your instance? A superior investigating agency at your instance has investigated and found that there is no foul play. Thereafter, you file a protest petition. On that basis, the cognizance is taken and he is taken into custody. I think that is no bail according to me. Do you want to say anything else?
But my lord, statements recorded under section 202 during inquiry, some clinching materials have emerged against petitioners. That is the only thing.
What are the statements to me?
My lord, your lordship may kindly have a glance. Annexure 3, my learned senior has annexed the depositions of the witnesses. 202 inquiry.
Show me one or two witnesses.
My lord, your lordship may kindly. Again. Page 31, your lordship. Statement of Bamano Barik. Statement of Bamano Barik at page 31, your lordship. In paragraph number 2. In paragraph number 2, he has categorically stated on the date 14/2/18 at about 9 AM the occurrence took place in the Shivaratri festival. While returning to our village, I saw that Sibo Prasad Behera and Ajay Barik was holding Saroj. Saroj is the deceased my lord. In one motorcycle, and Rajendra and Sudarsana were holding Kulamani. Kulamani is the other deceased. In another motorcycle and were proceeding on Bhadrak Dhamara road. On back of them, Kalipada Rai was going on with another two people in another motorcycle.
1 minute. Same witness. What is his name? His name is Bamano Barik. Bamano Barik was examined under one. No. These people have never been examined by the police because they have never been produced before the crime branch. They have never been disclosed by the complainant before the crime branch. How do you explain these people are not examined by the police in 161 by planning to do the report? These people may be planted witnesses?
No, my lord. No, my lord, absolutely not planted. Actually, those angles.
These are the circumstances doubtful. Because these people have never come forward at the time of investigation. How Bamano Barik is related to you, the informant?
He says in paragraph number 1, I know the deceased Kulamani and Saroj Padi. I know the complainant as well and the accused persons in this case, your lordship. He is nowhere related, my lord. He is not related. And that about the statement of the next witness is
What the prosecution can?
My lord, that about the apart from the last scene.
CD cannot be. There cannot be CD. Not be CD. Maybe the complaint case. Not prepared. After my lord has confirmed the LCR. He is not prepared. You just see. Problem now you understood. Problem is investigation says that nothing is. And 202 statements are recorded. Two witnesses, 3 witnesses say that last seen. But these witnesses were never examined under 161. Reason best known to these other witnesses might have been examined 161. Let's see 161. What are the witnesses who have been examined?
I have already filed. I have annexed it.
There are evidence. Just compare and tell me. I'll put it next to you. Yes, you are entitled. Otherwise, you are entitled. Please entitled. In the morning hour, you come here. Afternoon, you go.
My lord, in fact, my father is not ill. That's why I could not make it to time.
All right, it's all right. you
I may be
please come.
excused.
No, not excuse. You come to the court, then more effective. That's it.
My lord,
You are
my lord.
entitled to do it. No problem. Yes.
Both my lord, 55 and 57 next
55, 57.
7 next week.
He read in that line. Read in
My
that.
lord.
56, please, my lord. My lord, the present petitioner is in custody since 5/6/2023. 2023, my lord. 56. My lord, the charge sheet was submitted on 25/9/2023.
5/9.
2023. And my lord, the present accused is Subhas Naik. This is a case under 302. So my lord, so far as the my lord, witnesses are concerned, my lord, there are two eyewitnesses, and my lord, there are two my lord, extrajudicial confession involved in this case.
Eyewitness is there.
Eyewitness is there. Two eyewitnesses as per the charge sheet, my lord. What it reveals. My lord,
You have many material there.
my lord, not against me, my lord, in this case. My lord, I may be permitted to submit if there is any like.
Accused are there.
My lord, there are 5 accused. And so far as concerned, my lord, you lordship may just report that I am Subhas Naik.
Yes.
My lord,
See, eyewitness. You read your
eyewitness, my lord, first eyewitness,
one or two, one witness relevant party.
two eyewitnesses are there to Radha Naik. He is the informant, man. She is not the eyewitness. She has heard it. Radha Naik. Radha Naik and my lord, second is Sukanda Naik.
1 minute. Read. Subhas Naik, see,
he is not there.
ତାର ମୋଟରସାଇକେଲ ତଳେ ପଡିଥିଲା ସୁଶାନ୍ତ ମଧ୍ୟ ତଳେ ପଡି ଚିତ୍କାର କରୁଥିଲା ମୁଁ ଏହା ଦେଖି ଡରରେ ବସି ଆଡିଗଲି ଦୌଡ଼ି ଯାଇ ଲୋକଙ୍କୁ ଡାକିବ ମୋର ସ୍ୱାମୀ ସୁଶାନ୍ତ ନାୟକ ରାଜା ନାୟକ କାଳିଆର ଘର ଲୋକ ଅନ୍ୟମାନେ ଦୌଡ଼ି ଆସିଛନ୍ତି ଲୋକମାନେ ଶୀଘ୍ର ଆସନ୍ତି ସେ ଜାଗାରେ ଧରିକି ଅଭ୍ୟାସ ଦୁଇଟି ମୋଟରସାଇକେଲ ତେର ହୋଇଥିଲେ ସନ୍ଦେଶ ସୁଶାନ୍ତ ଏଇଟା ହେଲା ଟ୍ରିଟମେଣ୍ଟ
Sukanda Naik.
1 minute. No. Eyewitness.
Second is Sukanda Naik.
Eyewitness read. Eyewitness count and one. Complainant has not seen.
Yes, my lord. He has just heard, madam.
I understand, but read it. Let us understand.
Sukanda Naik, running page number 59.
Next time.
Is the eyewitness. Raja Naik is not the eyewitness. Sukanda Naik is.
What does he say? He says the same thing.
My lord, and
he doesn't take the name of
Subhas Naik.
ମୁଁ ରାଜା ଓ କାଳିଆର ଘର ଲୋକ ଅନ୍ୟମାନେ କଥାବାର୍ତ୍ତା ଦୌଡ଼ି ଆସିଥିଲେ ଲୋକମାନେ ଆସିଥିଲେ ସେମାନେ ସେଇ ଜାଗାରେ ଧରିଥିବା ହତିଆର ସହ ତାଙ୍କ ଦୁଇଟି ମୋଟରସାଇକେଲ
Okay, I understand now.
My lord,
and how he
extrajudicial.
I have called for the CD. He has read it.
My lord.
I have to see him.
My lord.
Yes. How have you linked him?
ଆପଣଙ୍କ ଗାଡି ଘରକୁ ଫେରୁଥିଲା ମାତ୍ର ଆଜି ସମୟ ପ୍ରାୟ 5ଟା ସମୟରେ ମୁଁ ଘରୁ ଫୋନରେ ଖବର ପାଇଲି କି ଯେ ମୋର ସ୍ୱାମୀକୁ ପୂର୍ବ ଶତ୍ରୁତା କାରଣରୁ ଜିଡି ବସ୍ତିର ବିଶାଲ ନାୟକ ସୁଜିତ ନାୟକ ଅଜିତ ନାୟକ ଟିକଲି ନାୟକ ଏବଂ ସୁବାସ ନାୟକ ମାନେ ପିଟିସନର ନାୟକ ମିଶି ବସ୍ତି ଛକରେ ହାଣି ପକେଇ ଦେଇଛନ୍ତି କିଛି ବିଚାର ନ କରି ମୁଁ ଘରକୁ ବାହାରିଥିଲି ପରେ ମୋତେ ସାହିର ଲୋକ ଖବର ଦେଲେ କି ମୋର ସ୍ୱାମୀକୁ କ୍ୟାପିଟାଲ ମେଡିକାଲକୁ ନେଇ ଯାଇଛନ୍ତି ମୁଁ ମେଡିକାଲରେ ପହଞ୍ଚି ଦେଖିବାକୁ ପାଇଲି କି ମୋର ସ୍ୱାମୀକୁ ମୁଣ୍ଡ ହାତ ଶରୀର ଅନ୍ୟ ଜାଗାରେ
ठीक है, but he has not seen, but he has heard. Evang Subhas Naik.
ଗଭୀର କ୍ଷେତ୍ର ସେହି ଲୋକ କହିଲେ କି ମୋର ସ୍ୱାମୀକୁ ବିଶାଳ ଗଲା ସୁବାସ ନାୟକ ଟିକିଲି ନାୟକ ସୁବାସ ନାୟକ ମିଶି ଘରକୁ ଯିବା ବାଟରେ ଅଟକାଇଥିଲେ କିଛି ବୁଝିବା ଆଗରୁ ସେମାନେ ପୂର୍ବ ପ୍ରସ୍ତୁତ ହୋଇ ମୋର ସ୍ୱାମୀକୁ ମାରିବା ପାଇଁ ଧରିଥିବା ଖଣ୍ଡା ଅନ୍ୟାନ୍ୟ ଅସ୍ତ୍ରରେ ମୋର ସ୍ୱାମୀକୁ ମୁଣ୍ଡ ହାତ ସର କରିଥିଲେ आज मु ड्यूटी कला बेले विशाल नायक सुजित नायक अजित नायक टिकिल नायक और सुभाष नायक बस्ती छके थिबा इलेक्ट्रिक खुंटी पाखरे आगुरु जगी थिबार मु देखिथि संदेह करथि जे एमाने किछि करि पारन आगुरु बस्ती रे ड्रेन पानी जागा विवाद को नै सेमाने आम ऊपर राग रखिथिले प्राय 1 मास पूर्व विशाल मोर धियारी रुबी को खराब व्यवहार करथिला जहा जोगु हम दुई परिवार मधे पाटितुंड होतला
Immediately preceding the crime, this witness has seen you along with the other accused person. This is what is the
My lord,
problem.
not me, my lord. What she says that
I'll tell you, two witnesses, so-called eyewitnesses,
yes, ma'am.
they have not taken the name.
Yes,
The
ma'am.
complainant heard it,
Yes.
but immediately preceding the crime, the same complainant has seen you along with this accused person congregating in a place to commit the crime. So, therefore, you have to wait till the eyewitnesses are rejected.
My lord, even if my lord there is extrajudicial confession, that also, so your lordship may just have a glance, my lord. They have not whispered, my lord. That is, my lord.
Whose extrajudicial confession?
My lord, the co-accused have to Prabhakar Naik and one Sanjeev Naik, my lord. There are also only those 4 persons' name only find a place, not the present petitioner. And my lord, if my lord may come to
extrajudicial confession, there also they have said the
yes, my lord.
said that
running page.
His name is not there. His name is not there.
Running page number, my lord, 55.
Let the complainant be examined at least.
My lord,
he is taking.
My lord, even if your lordship may just refer to the charge sheet, running page number 33, investigation itself reveals, my lord, 5th last line, if my lord may peruse. Running page number 33, 5th last line, starting from the case.
Yes.
The case was supervised by Sri M.R. Garnaik, SCP zone, and after supervision, he concluded that it is a true case under 302 and 34 of IPC against accused person, namely Sujit Naik, Ajit Naik, Vishal Naik, Tikili Naik, and Subhas Naik. But after that, no witness could prove presence of Subhas Naik at the spot during the time of incident. My lord, I submit, my lord, so far as overt act is concerned, no one has whispered anything about the present petitioner. And my lord, 302 allegation is specifically towards the other 4 accused, my lord. And at best, even if, my lord, the informant statement is taken, my lord, there might be a conspiracy prior to that, my lord. But overt act of...
I understand this much. I understand.
Yes, my
what
lord.
you say, maybe 120, not
it may be, my lord.
302.
It's not a 302 case, my lord. And in the meantime, my lord,
other evidences are also there.
my lord, against the present petitioner, my lord, it's not there, and already 5 witnesses have been examined out of.
Complainant has been examined or not?
My lord, one of the 2 judicial confession.
A complainant has been examined.
Complainant has not been examined, my lord.
Complainant is implicating you.
Complainant's, my lord, examination is.
Examined.
It's not examined, my lord. It's after 2 to 3 days, my lord. Exact date. Exact
2 days
date.
or 3 days. You don't know your
exact date.
Everything. How are you?
Exact
you
date,
have the
my
date.
I'll submit it, my lord. Exact date. My lord, so far as
Put it after 2 weeks.
My lord,
Awaiting the evidence of informant in the present.
Informant.
If informant evidence is recorded, you please give it. Because if the informant goes, there is
yes,
nothing against it.
There is nothing, my lord.
So therefore, informant, let us see the informant.
So, my lord, the custody
putting
period,
it after 2 weeks.
custody period is more than 1 year, my lord.
That's right, but see, it is a murder case.
My lord,
Can't be,
30 my lord, 302 is
there
not
is something because you were there.
That is
before
which
preceding the
that
crime.
is which the informant apprehends that there might be.
And you read the charge sheet.
Yes, my lord.
Charge sheet also it is there. So instead of getting it rejected right now,
my lord,
I'm not with you. So therefore, please wait.
Okay.
I may change my mind next time. I don't know.
Grateful, my lord.
But if that evidence of complainant is done, then I'll grant the bail.
Yes, ma'am. My lord, that your lordship may record, my lord.
I'll write that I'll grant the bail.
No, my lord. No, my lord.
I'm saying you file it. That's indicating that I
indication that
I have only adjourned it because to place that on record. If
yes, ma'am. Grateful, ma'am.
that goes without saying. Yes.
Grateful, madam.
58.
Yes. Yes. 58. 58, who is there? Offense? Non-APS in the interest of justice urgent. 59.
My lord. In this case, my lord, the offense is 30220 in IPC, my lords.
Yes.
Allegation is, lordship, the wife murder to his wife, my lord.
Wife?
Yes.
Yes.
Here, my lord. The
Custody?
petition- My lord, custody about to 6 months in jail custody, lordships.
6 months?
Yes. 3rd February 2024, lordships. And my lord, the case is based on only circumstantial evidence, no eyewitness to the occurrence, lordships. Occurrence took place in the year, on the time of.
When the charge sheet filed?
Yes, already charge sheet filed by.
When?
Charge sheet filed, my lord.
Just see the date.
On 29th May 2024, lordship. On 30/5/2026.
29?
May 2024.
20?
4 lordships.
24. You would go to trial court, right on. The petitioner is agreed by the order dated 6/3/2024, whereby his bail plea has been rejected. The subsequent thereto, on 29/5/2024, charge sheet has been submitted by the police. Since the bail plea of the petitioner was rejected during the investigation, when the investigation was going on, and subsequently filed, the petitioner should renew his bail plea before the court of first instance. With this liberty, the petition is disposed of. Yes.
60.
Obliged. My lord, the petition in custody since 1/2/2024, my lord.
1/2/24.
24, my lord.
Yes.
And the alleged offence is 363, 366, 376(2), and 365 and 6 of POCSO, my lord.
1/2/24.
Yes, my lord.
Yes.
And the last Sydney medical examination report, 164 statement of the victim, my lord. So far as the 164 statement is concerned, the victim was loving with the petitioner since two years back from the date of occurrence. And in the meantime, they decided to go for marriage. And subsequently, they went to their uncle's house at Sambalpur.
Where is 164?
No. He is at the time of occurrence, he was more than 17 years. As per her as per college certificate, I have obtained, and TC, my lord. He is more than 17 years. Oh, yes.
ରୋହିତ ମୁଖ୍ୟଙ୍କୁ 2 ବର୍ଷ ହେଲା ଭଲ ପାଉଥିଲେ ସେଇ ସମୟରେ ଆମେ ଭଲ ପାଇବା ବିଷୟରେ ପାଟି କଲେ 18/1/24 ତାରିଖରେ ରୋହିତର ମାମୁଁ ପୁଅର ବାହାଘରକୁ ମତେ ନେଇଗଲା ସେଠାରେ ମୋ ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ମୋ ସହିତ ସମ୍ପର୍କ ରଖିଲା।
Only this one.
ଇଚ୍ଛା ବିରୋଧ ନାହିଁ, ଇଏ 164 କୌଣସି no any force.
1 ଲେଖାଇ
1 I have 164, man.
Just see 160. You place 164 on record. 130. 3 You have to go to trial court. Particularly for another reason that in this petition, except rejection order, there is nothing. I have been struggling to find out what are the provisions. Nothing. You have not filed anything. I can't. You can't throw papers. I will have to read from here. There is nothing in this. I have been searching what are the offences. That also I am not able to get because charge sheet is also not filed. You keep it with you and argue it before trial court. The petitioner is agreed by the order dated.
And the birth certificate
agreed by the order dated 7/3/2020, whereby his bail plea has been rejected. I don't know. I can't write it also. Write down because you have not filed anything. and subsequently.
My lord, we need to filing the.
Counsel for the state submits that on 30th March 2024, the charge sheet has been filed. And counsel for the petitioner submits that at the time of the incident, the victim was 17 years of age, and the petitioner is 20 years of age. 20 years of age. All the charge sheet has been filed subsequent to the bail plea of the petitioner has been rejected during the period of investigation, and subsequently the charge sheet has been filed. Though therefore the petitioner expediently the petitioner should approach the court of first instance by renewing his bail application. The petitioner is given liberty to file the bail application.
My lord, another time may kindly give him to file all the documents of the regarding the birth certificate of birth of the victim girl, my lord.
You file it there. You file it there. File it there. The bail. Yes.
My lord, another date may kindly.
No. Yes.
61.
My lord, it is the duty of the prosecution.
What is the use of keeping documents with you without filing? Do you think that a rejection application is filed with a one-page application? Please grant bail. I'll grant bail. This is the way you people are conducting. There is no assistance from that side, nor from the paper also.
Another
No.
time may kindly give him to file all the.
Wherever there is no document, I'll simply dismiss. I'm giving you liberty, that much you should be happy. Yes, next. 61. Yes. Yes. Adjournment. Not press. Okay. Thank you.
Offense of 373, 363, 372, and section 4 of the section 6 of the POCSO.
POCSO, yes. What is your age?
Elopement case.
27. 27.
Trying to see the 164.
You see 164. You are in custody since?
Custody since 28/11/2023.
Yes, 164.
But there also charges also filed as well.
Subsequently.
Yes,
You have to go there. 25 file. नहीं rejection 28
Elopement case है 11 का वाली
28
160 पता है 160 date of birth is 28 2007. So at the time of birth you are 16 years old.
Read the because he is 27-year-old.
Yes. He is 16 years old victim. ମୁଁ ଯେତେବେଳେ 10 ରେ ପଢୁଥିଲି ଓ କୋଚିଂ ଯାଉଥିଲି ସେତେବେଳେ ମୁଁ ତାଙ୍କୁ ଦେଖାହେଲା ଜୁନ 29 ତାରିଖରେ ମୁଁ ତାଙ୍କୁ ଫୋନ କରି କହିଥିଲି କି ମୁଁ ଘରେ ରହିବାକୁ ଚାହୁଁଛି ଓ ଘର ଛାଡ଼ିବାକୁ ଚାହୁଁଛି ସେଇ ରାତି ଗୋଟାଏରେ ଆମ ଗାଁ ଛାଡ଼ିଗଲେ ସେଠାରେ ଆମେ ସାଙ୍ଗ ହୋଇ ଗଲୁ ଓ ଷ୍ଟେସନରେ ଟିକେଟ କାଟି ସେଠାରୁ ଚେନ୍ନାଇ ଗଲୁ ଚେନ୍ନାଇରେ ଗୋଟେ ରୁମରେ ରହିଲୁ ସେଇଠି ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଘରରେ ରହିଲୁ ସମ୍ପର୍କ ରଖିଲୁ ସେଠାରୁ 2 ମାସ ପରେ ଓଡ଼ିଶାକୁ ଆସିଲୁ ଭୁବନେଶ୍ୱର ରହିଲୁ ସେଟା ରହିଲା ଭିତରେ ଭଦ୍ରକ ମନିକା ମନ୍ଦିରରେ ବିବାହ ହେଇଥିଲୁ ସେଠାରୁ ଆସି ଭୋଟ ଘରେ ରହିଥିଲୁ ତାପରେ ପୋଲିସ ଉଦ୍ଧାର କରିଛି ଗୋଟେ ଇଚ୍ଛା ଭିତରେ କହିଲି or your mind is 16 years old
is problem.
How you get married?
No, not that. If the accused would have been little lesser than 20 years.
ବାହାଘର ରାଜି ଅଛି ବାହାଘର ହେଇଯାଇଛି ମନ୍ଦିରରେ ବାହାଘର ରାଜି ଅଛି ସାଙ୍ଗ ହେଇ ଦି ଜଣ ମାନେ କଥାବାର୍ତ୍ତା ହେଇ ଯାଇଛନ୍ତି
What about the family members of this boy?
ତାଙ୍କୁ ନୋଟିସ୍ ହେଇଛି OPG partner 2 ଦୈତାରୀ ସେଠି informant.
Nobody APS, huh? Your service complete them. Huh? Could not be. Requisite you have not filed. Huh?
Late filed.
File the requisite. File the requisite. Notice to the opposite party number 2 could not be served due to late filing of the requisites. Let fresh notice be issued utilizing the requisites which has already been filed. It is there now, requisite? Please the matter. Yes. Yes.
Here, my lord, the petitioner, my lord, is in custody since October 2023, my lord. And he has been charge sheeted for the offences under sections 498A, 304B, and 306 of the Indian Penal Code.
Yes. Charge sheet.
Charge sheet was submitted, my lord. And as my lord friend used to submit, case has been filed on 22nd March. So after submission of charge sheet. I have accepted your submission.
Yes.
Yes.
And the charge sheet under which provision? 306 or 304?
306, madam.
306.
Madam. 498A, 304B.
498 and all, and 306.
304B and 306.
Yes.
My lord,
You are appearing for? Informant.
marriage was out of law, my lord, and they married by an affidavit before the executive magistrate. My lord, as usual, my lord, the members of the deceased, they were not supporting their marriage, for which she was mentally sick, so to say, my lord. And my lord, she committed suicide.
She was disturbed.
Mentally disturbed, my lord. And it is alleged they committed suicide, and as per the postmortem report, cause of injury is suicide. Query was made. My query was made, and it has answered that suicide is it is a suicidal death. So ligature and
You show me that the family member of the deceased were not of the alliance. Because in the impugn order it is said that the materials on record do not disclose that the petitioner had subjected the deceased to any cruelty or ill treatment before the alleged incident. Only because of his wife committed suicide within 7 years of age, this has been done. If the family members are not supporting his marriage, her marriage, maybe she was in a different mental state. That might be the reason for commission of the crime. Show me that evidence. Do you have that evidence? See, under the presumption that marriage is within 7 years, it happened. It is a number. Right.
Subsequently, got married in a temple. Thereafter, he wanted 1 lakh rupees on others. Now, filling that one, he has been subjected to torture. Placing the statement of the Nomita Pradhan with the competent mother of the deceased.
No, I'm not on that. Mother and father will tell, obviously, because they were not interested in the alliance. You show me anything on record that their parents of the girl were not happy with the alliance.
Yes.
Anything is there?
Yes. I don't know about the law. ତାପରେ ଝିଅର ଶାଶୁ ବାସନ୍ତି ଯୌତୁକ ବାବଦକୁ 1 ଲକ୍ଷ ଟଙ୍କା 2 ଚକିଆ ଗାଡି ଇତ୍ୟାଦି ବାଧ୍ୟ କଲା। ଝିଅ ପ୍ରତିବାଦ କରିବାରୁ ସେଇ ଦିନଠାରୁ ଝିଅକୁ ଭଲରେ ଖାଇବାକୁ ଦିଅନ୍ତୁ, ଶାରୀରିକ ମାନସିକ ନିର୍ଯାତନା ଯୌତୁକ ବାବଦକୁ ଦିଅନ୍ତୁ। ପୁଅ ତାକୁ କହେ ଯୌତୁକ ନ ଆଣି ମୁଁ ପୁନର୍ବିବାହ କରି 1 ଲକ୍ଷ ଟଙ୍କା ଆଣି। This is the full before death, Lord. This has happened and it has communicated to the informant.
Where is that communication?
Complaint informant को
ବାସନ୍ତୀ ବେହେରା।
Yes.
ଗତ 5 ମାସ ହେଲା ଝିଅର ବ୍ୟବହାର ଭାରି ଭଲ। ଗତ ତା 13 ତାରିଖରେ ଭୋର ସକାଳୁ ଭଗିଆ ଘରୁ କନ୍ଦା କଟା ଶବ୍ଦ ଶୁଣି ସେଠାରୁ ଯାଇ ସ୍ୱପ୍ନାରାଣୀ ତାଙ୍କ ଶୋଇବା ପାଖରେ ମୃତ ଅବସ୍ଥାରେ ପଡିଛି। ଭଗିଆକୁ ପଚାରିଲେ ସେ କହିଲା କି ପୂର୍ବ ରାତିରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମଧ୍ୟରେ ପାରିବାରିକ କଳହ ବଚଟ ହୋଇଥିଲା ଓ ସୁପ୍ନା ତା ଘରକୁ ଯିବା ପାଇଁ ଜିଦ୍ ଧରିଥିଲା। ଭଗିଆ ତା ଉପରେ ରାଗି
କୋଉଠି ଫୋନରେ କହିଥିଲା ବୋଲି କୋଉଠି ଅଛି ଆଜ୍ଞା ଟିକେ ଦେଖନ୍ତୁ ମନେ ମନେ କହିଦେଉଛନ୍ତି ଆଜି ଫୋନରେ କୋଉଠି ଅଛି ବୋଲି ଟିକେ ଦେଖାନ୍ତୁ କୋଉଠି ଷ୍ଟେଟମେଣ୍ଟରେ କୋଉଠି ଫୋନରେ ଅଛି ବୋଲି ଜାଣିଥିଲେ ଆପଣ ତିଆରି କରୁଛନ୍ତି ଷ୍ଟେଟମେଣ୍ଟ କୋଉଠି ଅଛି ଓଭର ଟେଲିଫୋନ ମୁଁ ତ କୋଉଠି ପାଇଲିନି ମୁଁ ଜାଣିପାରୁନି କୋଉଠି ଅଛି ମୁଁ ତ କୋଉଠି ଦେଖିପାରୁନି ଜାଣିପାରୁନି ଆଉ ତମେ ଓଡ଼ିଆ ମିଡିୟମ ପାଠ ପଢୁଛି
I'll put it next week. Let him put it next week.
କିଛି ନାହିଁ ଗୋଟେ ମନ ତିଆରି କରୁଛନ୍ତି କେମିତି ଆପଣ it's not expected now.
See, the case is, try to appreciate, the case is the father and mother were not happy with the alliance. So maybe that is a reason for the girl to commit suicide. And earlier kidnap has taken place. In the kidnap case also the father is the informant. So that in that context you have to see whether any material. Yeah, that yes. You filed those things. You filed those. Yeah, better, yes. Yes.
No, so there is a prisoner's petition. It shows in the causeless moving. There is prisoner's petition apparently.
Prisoner's petition.
Yes.
Item number 107, for which my learned friend was interested for hearing criminal appeal. So I was asking him, you will not reach today. Why?
Today is. I'll just check it up how I can adjust. You please go. Don't be.
If the month of September, I have no objection.
First week September. 107 na? 100. You please get relief unnecessarily. No.
I have also.
We will conclude it. No.
On 6 September at 2 p.m.
Another item is there, madam. For 90 days, the lordship appointed amicus curiae as none of them appeared. In that case, whether senior advocate I heard today from my colleague, Mr. Gangadhar, that Mr. Sandeep Lal, the senior advocate, will appear doing this conduct case. Your lordship has already appointed amicus curiae in that case. Paperwork was to be supplied to the amicus curiae.
That's the problem. Nobody appears when I appoint amicus curiae. Somebody comes.
Nobody appeared. Today, he is to mention because your lordship that we will do that matter.
90?
93.
Note kar rakho. Yes.
93. So I have been supplied with paperwork. And the council who will contact with the Sandeep Lal, the senior advocate, they are having paperwork. And this amicus to the council was asking your lordship on the Friday that he has not been supplied with your lordship asked to so that it has been listed.
Okay. Let us see. Let it come. We'll see. You may go. You may go.
No, so there is a noting in the causeless about the prisoner.
What does it say? Dekho. Huh? Flagging. I want to change my advocate. I want to change my advocate. Engage Sri Suryakant Trivedi. Yes. That's the jail petition. Sajjita Mishra and so on and all. Raghunath Singh. All the name he has read. He has read. What to do? Peruse the jail petition. The petitioner seeks to engage. See, 3-4 names. Then Suryakant Dwivedi, one name, first name. So you only come. What to do? And the other names are also there, but since your name is there at the top, he wants to change.
I have no objection.
Please give the file to him.
Yes, ma'am.
Give to file. He desires to engage, disengage the present counsel and engage Mr. Suryakant Dwivedi, who is present in the court. Therefore, the Mr. So-and-so has supplied the copy of the petition to him. After 2 weeks, yes.
You can supplying a copy.
Yes, it is. After 2 weeks. Hmm.
68.
Yes.
On behalf of Alakmal Mahapatra, kindly give 2 weeks time for removal of defect.
What is this method? Passing of FIR. Business case. What is this case? Business case. We want adjournment. I'm giving two working days, you remove the defect. If you don't remove, then it will be automatically dismissed. Okay, in both the matter. If you remove it, please bring matter up to
17. My pleasure, Lordship. My Lord, defect has been already been removed.
Yes, sir.
My Lord, an application to purge the order dated 17/9/2022, my Lord, which was the application under 207. Because police paper has been applied to us, but the relevant document, one relevant document, that was the agreement, which it has not been supplied to us, and we prayed for the supply of the document.
Agreed by the order dated 17/9/2022, whereby the application in the section 317. Sorry, 207 seeking supply of certain documents form part of the charge sheet has been declared. Since the petitioner is entitled to the entire document form part of the charge sheet, the prosecution is duty bound to supply the same. Therefore, the interim order set aside, and the trial court is directed to IO is directed to retract the I know one paper is not directly has been given to the trial court. Directing the trial court to pass appropriate order, ensuring the supply of the copy of what? Copy of? Copy of the document.
Copy of the registration paper of file number 392105448.
Petitioner by the IO, with this observation allowed. Yes.
No, please.
71.
21 and 72, madam. They also issue notice. But the notice is that other than the opposite party to somebody has received the notice.
Other than opposite party to somebody else
received the notice.
Press notice. Press notice. 71
and 72.
Press notice.
Okay.
Press notice. 73.
73.
Yes. 73. Next 5. Modification of which one?
wrongly he has submitted that the charge has been framed against him. But in fact, there is no.
The prayer of the modification is allowed. Expiration charge has been framed according to paragraph so be read charge has not been framed. Then, which application is now pending? IA?
Yes, my lord, I.
Which IA?
1186.
Hmm?
1186, my lord.
1186, yeah. Double 186 is already allowed.
2043.
Huh?
2043 by 20.
2043. Which application is listed today?
2043 by 20 for modification of the order. So that's it.
The petitioner would prefer to file the discharge or petition against the Hmm?
Same number.
This is a earlier order. This is a why you are this has already been allowed. Fourth line of para 1 and 2, para and 2 of the order in place of charge has been framed against him. The modified line to be placed as a charge has not been framed against him, and the line for where petition will prepare to file against discharge petition before this also. None appears for the petitioner. Dismiss. We will not struggle like this unless
74. 74, my lord, the earlier notice was issued. However, Lordship has directed to face notice that has been lately filed. Accepted.
Accept karo and
Interim order was
entry. Why lately filed? Because interim order is
no,
there.
my lord. Filed previously, but that the notice was sought to the opposite party.
Why all these things are happening when there is an interim order?
I'm sorry, sir.
That the two surveillance is pending.
Same issue.
That has been tagged with us.
No, why is there?
No, my lord. One surveillance has been dismissed.
Another one is there.
But the other regarding other petitioner.
1056, right?
1056 is tagged with this. It is listed.
The other petition.
We'll see. But when once interim order is given, then this all kind of things are coming. No, not sorry. This is the practice. So you dissuade the court not to issue interim orders because of this conduct. The interim order is what? When the requisites were filed? The order was passed on.
Second time, the requisites have been filed.
7/3/2024. Within a week, just when we took it. 7/3/24. Direction was to file the requisite within a week.
Yes, sir.
When have you filed?
Instead of
Hmm?
after that one directed to file on 14/3/24, but filed on 34/24.
Huh?
Directed to file on 14/3/24, but filed on 34/24.
Just 15 days.
I may be excused.
No, you pay cost. Pay cost. This is a bad practice. What is the interim order? Stay of trial court proceeding.
Yes, ma'am.
Please. Otherwise, I'll vacate it. I'll vacate it and argue the matter.
Clerk will direct.
Right on.
Past payment has
There is an interim order passed by this court on interim order कब pass होता?
interim order, after the passing of interim order, I have filed the requisites. It has not been sought. Thereafter, Lordship has directed.
Whatever, all these things happen if there is an interim order. That's the underlining issue. Right on. There is a passed by this court on 19/1/2024. Subsequently, notices were directed to be issued to the opposite party number 3. By order dated 7/3/2024, this court directed the petitioner to file requisites within a week. However, the petitioner has filed the requisite much after the lapse of the stipulated period. In view of the interim order being continuing and the delay in the part of the petitioner to file the requisite, cost of rupees 500 is imposed on the petitioner to be deposited with the High Court Welfare Association also, and except the you have already filed, utilize the requisite which has been filed for serving requisite party number 2, leave the matter after 1 week. After 1 week. It is made clear that if you have already filed, yes, for final disposal, yes. That is why 500 you pay, and you keep on coming and paying 500 and ask for the interim order to continue. Interim order to continue.
I'll be pleased with them.
76.
May I do that? Discuss it. D to notice open number to not received.
Not sufficient.
What? Service awaited. Yes.
78.
Interim order is there. Yes.
78.
Why? What is this matter? Taxi. Yes. Failed. Mediation failed. Successful in dispose of. Successful mediation. Next week.
79.
May I please, your Lordship? My Lord, we have filed an IA 2087 for dispensation of the certified copy, as we have filed it in CRLNC 5120, my Lord.
What is this matter?
My Lord, it is a Sahi Gondogoda, my Lord. So, Friday notice issue heichi 5120. A chance of compromise is there.
Similar matter, 29.
Least 20. Yes. He has filed to yes. Final form in his favor.
It's not final report. Yes, his garage.
Acha, he has. ठीक है. Tell them.
Tell the matter may be tagged up.
29 na?
On Adjournment 29/8, similar matter.
29/8 similar matter is there. I'm getting it tagged with that. Okay.
Please.
Yes. The certificate copy is in the other.
Cognizance taking 379/4/2034.
Yes.
The petitioner is falsely implicated in this matter, Miller. And the FIR has been lodged with facts of the FIR.
Come to the charge sheet. What what the brief fact?
It's 25.
Come to the charge sheet. What are the allegations on?
79, 420, 21 MMDR Act, 15 Environmental Protection.
Read the charge sheet. If the case is made out, made out.
Yes. The fact of the case is that the Panch at Baish at 4 p.m.
Forget sir fact. You tell me what are the allegations against you. What is the allegation? Charge sheet.
Big layer miner, compressor machine, drill machine, and the vehicle that was seized when they are transporting the
Minerals.
That is the, and he is challenging the problem.
What is his name? Name is?
Suryanarayan.
As per the laborers present in the spot, their tractor illegally quarrying the spot by the direction of Suryanaran Bhuya and so and so, so and so, and all.
All these persons were illegally drilling and theft of minor minerals by cheating government revenue.
Persons were illegally drilling and thefting the minor minerals by cheating government revenue by using the seized tractor, and the cause of damages to the environment, and hence the report along with this is the report. Rightly the cognizance is taken. Cognizance what to do? These are the allegations. Write down. I peruse the allegation made, peruse the FIR and the charge sheet, subsequent charge sheet filed by the police. There are direct allegation against the petitioner made by the informant, and the investigation also revealed the same. Therefore, court below has rightly taken cognizance of offence under section so and so, so and so, so and so. Wide order dated 17/11/2022. No, 17/11/22. I'm not inclined to entertain this petition. However, liberty is granted to petitioner to raise all the points before the trial court at the appropriate stage. Yes, next.
81.
Not
Kindly give us some time to remove the
defects. What is this matter?
This is passing of criminal proceeding, often 72nd, 76.
Stays. Charge sheet has been filed. Cognizance is taken. 20 cognizance is taken. Now you are coming after 4 years. Trial might have been over by now.
I don't have the instruction of my senior.
Why are you filing, huh? Rejected.
2009. After second order was filed, you might have not surrendered, but that is me have filed.
What are how many defects? Defects can be ignored if you can argue.
I don't have the brief also.
You should have got the brief. You got an opportunity to argue. You should have argued. Huh? Minor defect I'll ignore. Forget about the defect. Will you argue tomorrow?
I don't have the brief.
You get the brief from your senior. I'll put it tomorrow. Argue it. Huh? Tomorrow. Let him argue. But you have to argue. Otherwise.
Yes, my lord.
Yes. Yes. What defects? Many defects.
Undertaking and orders. 81, 83, I do.
FIR investigation is on or completed. He has only filed a. Huh? Oh, that's right. He has only filed. Whether charge sheet is filed or not, I don't know. Charge sheet has been filed. Why are you filing the petition then? This is December 2023. This petition is filed. You have filed in this petition. You have filed in December 2023, seeking passing of the FIR. In the petition, only FIR copy is attached. Whether charge sheet has been filed or not, 1 year has passed now. When the charge sheet was filed? Hmm? You are holding the file, you don't read it. What is this? You are there.
No, item 70.
70 is gone. Or 2 days I am giving for curing defect. If you don't cure it, it will be automatically dismissed. The petition is saying since 12/12/23, defects have been pointed out by the registry, but the petitioner has not cured. 2 working days have been granted to the petitioner to cure the defect. If the defect is not cured within 2 working days, dismiss without reference to the court. If defect is cured, release the matter next to the court.
83.
Same. Why are you filing this kind of petition? I just don't understand.
84.
1 minute. This petition is also pending from this same. Lot of defects. Only 1 FIR. Why are you filing? You are burdening the court. 2002 FIR. Charge sheet might have been filed by now. In this case also anticipatory bail rejected. Release it tomorrow, we'll see. Both the matters. You tell your senior to come. I'll dismiss both the matters. Both the matters. उसका पहला वाला matter. हाँ. This is enough here.
84.
I'm listing it tomorrow. You come. I'll dismiss both the matter. There is nothing unnecessary. There is nothing in this matter. It's unnecessary pending since years and years.
84.
This is a case of totally improbable.
Huh?
Totally improbable. My lord, the
Improbable or probable will be decided in the trial.
my lord,
I can't decide. It is improbable, therefore I'll pass.
my lord,
Your beginning sentence is wrong.
my lord, initially the FIR was registered under section 341, 323, 509, 350.
Yes, forget. The full IPC is there. You can't read it.
My lord.
Charge sheet filed.
Charge sheet under section 376.
Cognizance is taken.
My lord.
So charge sheet and tell me the
My lord, thereafter the petitioner filed a discharge petition on where the Lord additional district judge cum first trial court Kendrapada has discharged the petition from the charge under section 493 of IPC read with the 67A of Information Technology Act. And only the trial has been commenced under section 3776 to N. My lord,
Yes.
the petitioner is the friend of the husband of the victim. My lord, victim is a married lady having 2 children. My lord. The food order is annexed 3, my lord.
173.8 is open so far. Huh?
No, discharge is like 32. Regarding the offense under section 60. Hence, the accused stands discharged from the said offences. However, there is a ground to proceed against the accused for the rest of the charges. Offense hence be called for discharge for charge. The accused remains present on the page 32, second paragraph.
Because you could not seize any electronic this transmission materials. So therefore, 67 and 67 capital is gone.
Due to family dispute between the
Whatever, 164, you have 164. You have 164 statement. Read it like 2 weeks back.
85.
Nothing. They just forget this day.
May please lordship. My lord.
And you are discharged in many offences. Only 376 is there. You have to file the relevant document. You have not filed anything.
My lord, I will follow.
Then how are you asking for stay without filing anything?
85.
May please lordship. My lord, and you take no side.
Hmm?
Side.
Why?
Because the Law and Council on behalf of the opposite party, sole opposite party, is out of state. So he
This is,
instructed me
you filed in December 23. This is pending.
My lord.
I don't think you are serious about this matter.
My lord, I am reading it. Because the Law and
There is an interim order.
My lord, there is the Law and Council on behalf of the opposite party instructed me on the.
No, forget about the opposite party. You have got the interim order.
My lord, I am ready.
After interim order, you keep on asking adjournment. 2 adjournment you have taken already.
My lord, I am ready.
Ready, are you?
My lord.
If you have a case, you have a case.
My lord.
Yes.
I have filed this application, my lord, for quashing the.
Use the mic.
Here, my lord, I have filed this application for quashing the domestic violence proceeding against the petitioner, my lord. The fact of case is that the petitioner is the aunt of the opposite party. There is no allegation against the aunt-in-law in the domestic violence, and the petitioner is residing at Chandor in the district Kendrapada.
You relied upon Durga Das Panigrahi
My lord,
to say that
she is not a
she is not
share
staying in
household.
the same sharehold.
My lord.
Sorry, sharing the domestic this thing relationship. So therefore, you can't be sued in that.
My
on
on
TV.
that
Then she has
no,
to-
here is a decision of this.
Why she is not there? Service is complete. Service is complete.
My lord, sir. Opposite party appeared.
That none appeals for the opposite party number 2. For the
Only opposite party, my lord.
and so and so appears for the petitioner. Only opposite party, yeah?
My lord.
Only opposite party. In the interest of justice, entry want to continue.
86.
I've got to see the copy, man.
Modification of this is the modification of lordship's order mirror. In paragraph 2, stepping account number has been mentioned.
Paragraph 2 of 775 order. 7524.
My lord.
Paragraph?
Paragraph 2, my lord.
Yes.
Sabi account number has been wrongly mentioned, my lord. I am in my petition, my real account number is 1016114.
This number we might have got it from your petition
Twice,
only.
CC account number twicely mentioned, my lord. Saving account number has been wrongly mentioned.
Where from I'll get this
My lord, in
number?
paragraph 1, my lord, my petition, my lord.
Paragraph 1.
1 in my petition, my lord. Page 2, my lord. Challenge the order dated passed by the Law and Additional Sessions of Keonjhar, wherein the petitioner prays for a release of the freezed saving bank account number 1016114.
I understood. 575/2024. Order account numbers are different. Account number issue petition route लिखा है कि issue route लिखी थी? Correct.
My appearance may be noted. I'm for opinion number 2.
We'll correct it. Correct it looking into the account number.
May I please, my lord? My lord, I have filed an interim application for extension of time, your lordship.
Extension of what time?
Extension of time, lordship may kindly peruse the order dated 19/3/24. The operating portion, Therefore, the complaint case being 1cc case number 347 of 19 is restored to its file, and the complainant petitioner is directed to file the evidence by way of affidavit on or before 10/4/24. So,
This is 138.
yes, Your Lordship. Here the petitioner is the complainant whose complaint petition has been dismissed due to non-filing of the evidence on time.
So why are you not filing?
My lord, here the difficulty is that the petitioner, being the lady, has went to her husband's workplace.
But see, these are 138 matters. I gave one opportunity. It's again you are not doing it.
Only, Your Lordship, I pray for 1 week time.
See,
Being a married lady and children were also
April
there.
2024, time was granted. Today we are in August. When you have moved the application?
I have moved the application on 19/3, Your Lordship.
March.
March.
How much time you wanted to ask?
Only 1 week time, maybe.
1 week.
1 week.
March you moved the application. Today we are in
August.
August. Still you want 1 week.
Time to lapse.
You got about 5 months. You move an application in March saying that I need 1 week time extension.
No, sorry.
When you move the application?
Main order has been passed on the on 19/3, main order.
I know that 19/3. When you move the application, I'm asking.
That interim application?
Yes.
Interim application I have moved on 6/8/24.
6/8?
I have filed on 6/8/24.
Today we are in?
And today it was listed, Your Lordship.
So 1 week is over. You got it.
No, today it was listed.
No, that's right. From the listing 1 week. Suppose it would have been listed after 3 years. Still 1 week.
No, there is some urgency.
Have some logic moving application.
Only I am praying.
This application was moved on 5th of August 2024.
5th of August, sorry.
5th August 2024.
5th August I have filed that application.
Yes. Today we are in on 12th.
12th.
So as it is, you got 1 week.
List even.
Right. Petitioner is seeking extension of time granted to him by the order dated 19/3/2024 till 10/4/2024 to file his evidence by way of affidavit. And see, you are moving application in August. I had given honor before
10/4.
What is this? Completely frivolous applications. Completely frivolous application. And it's 138 matter. You are the informant.
Yes, Your Honor. Complainant.
For the reasons stated in the application, 1 week time of extension is granted as a last and final opportunity. 1 week means today is the 12th, 13th by 20th, 20th April, 20th August, on or before 20th August.
On or before
20th August, yes.
Urgent certified copy.
88.
May I please your lordship? This is bail matter, madam, and I have filed for extension of time. On
Order dated
24/3/2024, this honorable court was disposed.
22, pay 500, 500.
Sir, already
On or before 31st of August, you appear.
Sir, already pay cost, sir, 500 rupees.
Then what does he want then?
Extension.
Oh, 31st October. For the reason stated. Yes.
89.
89, my lord, I filed interim application for extension of time, my lord. My lord, due to
extension for what?
Extension to surrender, my lord. It was your lordship has ordered on dated 6/5/2024 to deposit 500 and go on bail to and release on bail matter in NBWK matter. So
you filed subsequently another IA you filed.
No, my lord, I have filed this due to viral fever. I could
1275 also you filed and sought adjournment. You say that you will not proceed. What is this application?
2012 matter, then LBW was passed, the lordship directed to surrender and subject to condition that deposit of 500 rupees.
I have deposited 500 rupees.
Surrender date was 36/2024.
Yes, ma'am.
Now after 2 months, the reason that he was suffering from viral and
Yeah, he moved another application in between. 1275. I am just wondering what is that application. You didn't press that. What is this application?
that is also matter prayer is to surrender, property to surrender because of one court.
You moved, do you know? You have moved an application.
Yes.
What is that?
That, my lord, for extension of time, and could not surrender, so that's why.
You didn't press that application. You didn't press the application again. You are moving up an application. Another 500. Let him pay another 500.
Already deposited, my lord.
Extension of time granted up till 30th of August with the further cost of 500 rupees. In view of the fact that after the order dated 6/5/2024, the petitioner had moved an application IA number 1275 of 2024. On 17/5/2024, he did not press the application. And subsequent thereto, the present application is moved for the same cause. Therefore, 500.
90.
And it is made clear. So extension made clear that no further extensions are given here.
A petition for extension of time to surrender before to appear before the court below, my lord. Yes, due to the petitioner is a married lady, who is residing, who was residing outside the state with her husband. Due to illness, she could not come.
Oh, extension for the reason stated, extension till 30th August. It is made clear that no further extensions.
Another one thing, my lord. In this case, one in paragraph 3, petitioner was it has been inadvertently mentioned as 15/6/2025, petitioner was released on bail. But in fact, I have mentioned in the petition and on dated 11/12/2012.
Para 3 11 ಕೊಡ್ತೀಯಾ 11/12 ಕೊಡ್ತೀಯಾ 50.
He was released on bail.
2005 11. Okay.
And the last occasion, I have deposited the amount.
Yeah.
Okay.
92. 91 petitioner died arbitrated.
We have already filed the petition. My lord, last time we allowed the petition. For substitution, we have already filed the consolidated first writing.
91.
91.
Okay. There are two petitioners, na?
For condemnation or bill and
91 the order person, already there is an order.
last time my lord has passed the order.
1 minute. This is for this Gangadhar Behra.
Gangadhar Behra, one of the accused, one of the convict, and another person's my lord, senior my lord.
Criminal appeal number
Sub item 2.
No, last time I have not passed any order.
Hmm.
I have not passed any order. Last order is that I have sought information from the vigilance department regarding the well-being. Today they have said, and I have disposed of saying, where is your application?
My application is my lord in 192, IN number 176.
No, first you tell me about this Gadadhar Behra. Have you moved the application? Where is that?
Malad, two miscase, malad. One is the malad substitution, another malad the condonation of delay. Malad IFR.
Which IA is for what?
Malad 1298 of 2019.
This is, acha, this is not allowed so far.
Last occasion, my lord, your lordship directed.
Wait,
my lord,
last
wrongly-
date, batao, date, there is no order. There is no order here.
10/7/24.
Huh?
On 10/7/24.
Thereafter.
There, I order thahi, kintu your
Show me
lordship.
the order if you have.
19/7/24, madam.
No, order sheet does not show, my lord, but your lordship
Directed for which you have filed.
consolidated cost item.
Right, there is no order. Right. Application wo allow korte dono application. Application first one is 1298.
My lord,
The
1298.
sole appellant has died in this appellant case, so therefore the petitioner moved application 1298 under section 394 CRPC for taking leave to continue the appeal. I allowed. And what about the other one?
Other one, my lord, the condemnation of delay,
Condemnation of
1652.
delay allowed for the reason stated. Bag.
Back, my lord, I have filed 1765 of 2024 for substitution and 1763 for condemnation of delay.
Okay.
And we have already filed, my lord, the consolidated cost appeal.
Consolidated cost appeal in both the cases has already been filed. Yes.
But that may be fixed for a hearing, my lord.
Well, that will remain in the weekly. Thank you.
92, Your Lordship, I'm on behalf of appellant number 1. On the last occasion, Your Lordship, my senior completed his part of the submissions, and Your Lordship had asked us to submit a detailed written note of submission. So I've prepared this, if Your Lordship
I'll have
kindly
to-
accepts that.
What is this matter is about?
The matter is with respect to, it's a vigilance matter, Your Lordship, the person.
No, there are other appellants.
I am from 13,
There-
18 of 2011.
There are 3 appeals, Your Lordship.
It is fixed for them. They
My-
have to argue.
My lord, CRL 13 and 18, I am for the amicus query. So copy will communicate.
13, but he is appealing.
I mentioned.
13.
Huh.
Appeal
No, no,
13.
not 13, 18.
18.
And Your Lordship, my senior, Mr. G. Mukherjee, is for appellant number 1, CRLA 59 of 2011.
I know that you give your written submission.
And copy will communicate me, madam. 13 and 18.
13 you are appealing.
13 and 18 I am from amicus query, as per the court order. Serial 13 and also serial 18.
Order dated?
I don't know. A lot of copy will not communicate, only message will communicate me. So that's it.
Yeah. But you were appointed by this court when?
Hello.
When you were appointed? I don't find the order therefore.
Yes. But I had order not communicated, but as per message, my name is also reflected.
Appointed?
Yes.
25th July, this matter was last heard.
No, that day it is heard. Just looking at this, when Mr.
By-
Das has been appointed.
Yes. Yes, sir. Yes, yes, sir. The court order passes.
There is no order to that effect, or the order is not uploaded? What is this position?
No order, madam.
Huh?
No order.
By again and again,
Just verify, let them verify.
Yes.
Verify. We'll see.
You know, any other date will fix, I will take.
Fix a date.
By the Honorable
Verify. When Mr.
Justice
Das was appointed. what is
Sanjay
it?
Mishra and also yes, one of
Because he is appearing for 3.
Yes.
3, appeal number 3. 18 you may have to appear.
Is there any order?
13 later.
Yes.
93 कॉपी भी पाइने किसी पाइने में जाने
Just Sanjit has mentioned. Just Sanjit not.
93, na?
93.
93, who is appearing?
And then
That he's going to give a date.
Yes. That's item number 93 on behalf of my learned senior. We haven't received the pay as yet, my lords.
My lord, item 93, my lord. Here in this case, Mr. P.K. Mishra, my lord, was appear amicus curiae, my lord. Today we have filed the binama for appearance, my lord.
Hey, you don't come and once amicus curiae is appointed, you appear all of a sudden. He is already prepared. You file binama, let us see. I don't know. We'll see. Appointed amicus curiae on necessary time. You didn't appear for longer time. You file wakalatnama, we'll see.
Obligers.
Adjournment.
94.
Correction of typographical error. What correction? The order number 3 shows at 0.5 order. Correction could be correction error. Yes.
95.
May I please, your lordship? My lord, this is an application for quashing of the proceeding in one CC case, which is pending in the court of learned SDGM Bhubaneswar, your lordship.
Yes.
Here the petitioner number 1 is the wife of the opposite party, and the petitioner number 2 and 3 is the parents of the petitioner number 1, your lordship. My lord, here the marriage took place between the petitioner and the opposite party at Vizag on 11/2/2007, your lordship. Meanwhile, on 26/12/2011, the husband filed a case under section 13(1) of Hindu Marriage Act against the petitioner number 1 for a divorce, your lordship. On 14/2/2013, your lordship, petitioner number 1 filed a petition for transfer petition, case number TRPC number 218/2013 in the Honorable Supreme Court, your lordship. The husband appeared in the transfer petition and submitted that the petitioner number 1 has made a misstatement in the TRPC petition, that the husband is residing at Vizag. Although factually the husband was staying at Bhubaneswar, on 1/7/2013, in spite of the such objection made by the husband, the Honorable Supreme Court has passed an TRPC petition allowed the TRPC.
Are you complaining on the order of Supreme Court or what? What is
No, lordship. Lordship, here what happened, the matter is, here the has taken on cognizance in 160 case regarding the misstatement made by the wife in Supreme Court, and the matter has already been allowed.
You have to go get it corrected there.
Yes, your lordship. Our stand is that only. But the magistrate here has already taken the cognizance under section 200 of TRPC. Sorry, your lordship, TRPC.
Magistrate might have gone on the basis of the statement made by them before Supreme Court, which is accepted. Your counsel should have been alert enough that to take objections. Cause of action arose there or cause of action is there.
Cause of action arose in the Honorable Supreme Court because the statement has been accepted in Supreme Court.
Where is that order? Supreme Court order.
That order is, your lordship.
You filed it or not?
Sir, I have not noted.
Your entire case is revolving on that particular order. That is not there.
Yes.
Everything is there except that. You started arguing with that order first.
Lordship.
Show me that order at least. Show me here. You should file. That is the basis of your entire attack to the proceeding. You should have placed that
Lordship, I only received the file right now and appearing on behalf of senior advocate S.S. Rao. That's the only problem, your lordship. Otherwise, you
want to see that transfer petition order. Do you have that?
I have it on the phone. May I read it out? I don't have the copy. I have it.
For a reason, I'm asking.
I can get a printout if the lordship may pass over the matter.
Isn't it? After 2 weeks.
98.
My lords. Please, your lordship. 98, I am there. Here we have challenged an order of cognizance, my lords, taken against the petitioner, my lords, alleging abatement of suicide at his instance, which is not made out from the materials on record, my lords.
Yes.
Your lordship has in the meanwhile issued notice and granted interim relief to the petitioner. Petitioner before your lordship, my lords.
Service complete.
He is a contractor, my lords, and it is alleged that he had taken a work on contract.
Let us see whether service complete or anybody is appearing. Just check it up.
Extra copy, sir. Extra copy, yes, sir. Some to government.
No, opposite party number 2. You're not implemented opposite party number 2.
No. Not it.
When the notice was issued?
In item 98.
Yes.
Just a moment.
And extra copy is also not served.
But actually, I am appearing, my lords, on mention, my lord, on appearance. The last order was passed, my lords, on 2022.
Ah, there is direction to serve the extra copy.
I'll check up with my instructing counsel, my lords. Can your lordship adjourn it to some other date with the
Order
interim?
dated 12/8/2022 has not been complied. Complied 1 week time is sought by Mr. Ponda for compliance of the order. Urgent. Yes.
99.
Lords, my name may kindly be reflected.
Yes.
Lordship, I'll file a memo.
May be reflected in the cause list.
99 one password मतलब
I am appearing for. I am for the petitioner, my lord.
Till midnight. Just see the time.
No, my lord.
While I am rising and you are asking for password. Let it be there. We'll see. Yes.
My lord, next week candidate.
Item 100.
Next week candidate, my lord.
Yes. He'll give it. Yes, 100.
My lord?
How many matters are left?
108.
Yes.
May I please, your lords?
Yes.
So, my lord, petition is challenging the order passed by the honored JMFC, your lordship, summoning that the petitioners are the in-laws, your lordship. All the relief sought for by the opposite party number 2 can be only be met by the husband, the maintenance and whatever the thing is as per the DV Act.
This petition is arising out of
DV Act, your DV Act. And petitioner number 1, it is not satisfied the definition who are the respondents, can be respondents in the DV case, your lordship. You can see section 2Q, your lordship. Any adult male person who is or has been in domestic relationship, your lordship. Petitioner number 1 is the mother-in-law and the 2 is the your lordship sister-in-law, your lordship. And this, they are not been staying in the share household. Relief sought by the opposite party, the wife, from the can be only be made by the husband who is working. Your lordship, there's an
service is complete. Who is
yes, someone is appearing, Mr. On last date of also hearing also, then nobody appears, so therefore the your lordship adjourn the matter. Your lordship says Apex Court also judgment that it's if only omnibus allegation and so your lordship has.
Somebody has to appear.
Last date of hearing also nobody appears. So therefore, your lordship adjourn the matter.
Somebody appeared on 8/9/2024, just see my order.
Last date of hearing also nobody appears. So therefore, your lordship adjourn the matter.
Vakalarama is there? Anybody? See, somebody, M.R. Samantrai
Yes, yes.
appeared for opposite party.
Yes, yes, yes.
And thereafter he didn't appear.
Yeah.
The order I passed is in the interest of justice, release the matter on such and such day. It is made clear that in the event Mr. Samantrai, counsel does not appear on the next date of hearing, the matter will be taken up without further adjournment.
Mile.
That was the order.
Mile.
Thereafter what happened? And this is a domestic violence act case.
Mile.
And if Mr. Samantrai has filed Vakalatnama, or has he appeared? He has filed the Vakalatnama. Right. You have an interim order.
I have an interim order.
I'll give you a long read. Right. Notice was issued to opposite party number 2. Mr. M.R. Samantrai, advocate, entered appearance. However, he has not been appearing in the court. Therefore, on 4/8/2024, this court has directed that in the event the Mr. Samantrai would not appear on the next, the matter will be taken up without further adjournment. Still, the matter was on 2/5/2024. The matter was adjourned in the absence of Mr. Samantrai. Even today, the none appears for opposite party number 2. In view thereof, the matter is adjourned to after 3-4 weeks. The interim order to continue. Let it continue.
It's a petitioner. It's my lord knows that the law is now, the Apex Court has said that only omnibus allegations against the in-laws.
Right. See, these are packaged, you know. If matrimonial dispute starts, 5-6 cases.
Yes.
498,
Yes.
DP
It
Act,
is
120B,
yes.
Section 9, everything is fine.
It is continuing.
Full package.
Lordship, the
Same allegation.
husband, after filing the divorce petition, all these things has been happened, your lordship.
What? This is.
My lord, my interim order to continue.
Interim order to continue. Yes.
101.
A date is.
Yes.
One minor questioning of FIR, my lord. The case is the year of 2017. Till date, charge sheet has not yet been filed. For which on dated 5/8/2020.
2017 matter. Why it's not filed?
In that the investigation of this case is continuing and pending for further investigation by the foreign direct. So then I have transformed that it was
7 years.
My lord, the material says against him.
You have not investigated what material?
No. My lord, can see the Caesar one, page 45. Page 45 of times.
25.
But in the case diary, I will obtain the case diary. The case diary, my lord, from the present petitioner, magazine, pistol, live ammunition, it was seized.
It is 353/34, huh?
353, 25, 35 hours.
It is recovered from him.
Recovered from.
What is this then? This is the FIR. Do you have any judgment if the delay in investigation for more than 5 years, it can be passed?
Well, I will prepare again short adjournment.
You came for adjournment or you came with some preparation?
Without prepare, my
Come
lord.
with the preparation, that is only your case.
Yes, ma'am.
Irrespective of
Because-
whatever the allegation. If the investigation is delayed for such a long time of 7 years, the FIR can be quashed. That's
Next
your
week-
case, then you have to come with that.
Yes,
preparation.
ma'am. And another thing, ma'am, in this case, the investigating officer, that is the SI, there is a dispute between the present petitioner along with the SI, ma'am, for which against him.
That man is already transferred, somebody else is doing.
Yes, yes.
Yeah.
So with
Somebody
an
else is
ulterior motive, my lord, stock with on another gun, my lord, he has initiated the case against me, ma'am.
That
I'll-
Pitambar Naik has already gone.
Yes, ma'am.
Somebody else has come.
Next week, my lord.
Saying that another one, because not saved from the present petitioner and on the.
You don't have a case. I accept you show me that delay is so fatal that it
Yes,
can be
my lord.
quashed also.
Next week, my lord, any day.
Not the next.
103.
Present status.
Hmm? Like, so please show live. Yes.
104.
Hmm?
Hmm.
Period undergone.
Kindly taken up next week.
You have to see from the record and tell me period undergone. You tell me period undergone. You sit with these people. LCR is already there. From the LCR, you check it. Check it up and tell. Put it on next week any day. Tell me so that we can finish it up. 2014
Argument already over, my lord.
argument is already
How
over.
many is
How many days he remain custody or sentence?
that is verify causing of CD nine.
CD.
From CD, you put it tomorrow. Let him do it.
Pen
I'll
drive
finish.
Let it come next week.
No, Abhi, now you sit down and tell me. Only undergone period 2 minutes. Matter is heard. Unnecessary, this matter will be pending. And tell me so that I can.
Item 106,
Everything will remain.
Sorry, sir. Oh, sorry, adjournment.
sorry, se koi ଦେଇଛନ୍ତି ମରି ଯାଇଛି ଫାଇଲ କରିଦେଇଛୁ ଆଇଏ already
Adjournment.
ମରି ସେ କହି ଦେଇଛୁ ଆବେଟମେଣ୍ଟ